Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. Almost 7.5 hours of argument time has been requested, so we're going to have to trim that a bit. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise, let me know who you represent and how much time you are requesting. People v. Christian Cruz. I'll give you 3 and 1 and 3. 513 West 26th v. George Billis Galleries. You want rebuttal time, counsel? Oh.
The appellant, George Billis Galleries, and George Billis, James Marsh. I request 5 minutes and I defer whatever else time the court grants to the city of New York, because I think they have a heavy burden.
I take it we're sure the respondent is not here?
We were told, I got a letter from him that he was going, he wanted to go on submission.
He filed a letter on the docket.
I missed that, okay. We'll go with 4 and 4. B. Children is submitted. Borokov v. Roth and Khalife. Do you have an opponent present? Oh, you're the respondent?
Yes.
Is the appellant here? Do you want to address the court, counsel, or you want to submit? Okay, we'll take submission. Thank you. You're done. Siguencia v. the Hudson Companies. Give the appellants 4 and 2 and 4 and 2, and you two 3 and 3. People v. Robertson Ortiz. Submitted. People v. Jermaine Jacobs. Submitted. Adago v. Sai.
Representing plaintiff respondent Adago, and I'm requesting 8 minutes.
4 and 2 and 4. Park Row v. Jiha. Justice Rosado is recused on that case. 4 and 1 and 3. CS Leveraged Loan v. Bank of America.
For the appellants, Your Honor, 7 and 3.
5 and 2 and 5. You don't have a cross appeal, do you, counsel? No. New York City Transit v. Local 100 TWU. How much time?
4 and 1.
Okay, 4 and 2 and 4. The application for warrant to search premises at the Art Institute of Chicago and the special proceeding, the Article 78, and the matter of the application of Art Institute of Chicago will be heard together. I'm going to give you 8 and 2, and I'll give you 9. A1 Specialized v. James River. 4 and 2 and 4. Brito v. City of New York. I'll give you 4 and 2 and 4 and 2 and 5. People v. De Jesus. Submitted. Rigaud v. 509 West 34th. 4 and 1 and 4. Fisher v. Hudson Hall LLC. I'll give you 4 and 2 and 4. People v. Santos. Submitted. Burke v. River Bay is submitted. First case up is People v. Christian Cruz. Please.
May I proceed?
Please.
May it please the court, Liliana Rembar from Cleary, Gottlieb, Steen, and Hamilton, pro bono counsel for Christian Cruz. We are seeking a modest sentence reduction in the interest of justice. We make this request in light of Mr. Cruz's traumatic and unstable childhood, his status as a veteran, his myriad mental health issues arising from his years of military service, and his desire to put his life on the right track.
This was his second felony conviction, is that correct, counsel?
Yes, Your Honor, that is correct.
Counsel, didn't the sentencing court take all that into consideration when he got 12 plus 5?
Yes, Your Honor, the sentencing court did note on the record that she was considering his military history and his mental health status. As you know, this court has broad interest of justice, power to reduce sentences when it feels that the sentences should be reduced. I would also like to draw the court's attention to Mr. Cruz's childhood, which was in the record before the court, but it is not clear how much the court considered that.
What was the maximum Mr. Cruz was facing if he didn't take the plea?
Mr. Cruz was facing 25 years on the plea. Growing up, Mr. Cruz witnessed.
The people wanted consecutive time on this case.
Sorry, Your Honor?
People wanted consecutive time on this case.
Yes, Your Honor. The people did want consecutive time, and the judge of the sentencing court.
To find mitigation in order to even give him the 12 concurrent to the 9 in Queens County. That's
right, Your Honor. The sentencing judge in the case did find that there were mitigating circumstances in order to run the sentences concurrently. I would argue that the sentence of 12 years of incarceration and the 5 years of post-release supervision is still excessive in this instance in light of the facts surrounding Mr. Cruz's background. Despite the issues that Mr. Cruz faced growing up, he sought to serve his country. He entered the military in 2004 and served for 8 years as an explosive and weapons specialist. He sustained numerous concussions and blows to the head. In 2006, while in a tank, he was in close proximity to an explosion and he hit his head, which resulted in a traumatic brain injury. And he was also physically assaulted by fellow Marines during his service. So these circumstances together have resulted in serious and long-lasting mental health issues. Mr. Cruz has been diagnosed with post-traumatic stress disorder, with major depressive disorder, bipolar disorder, and substance abuse disorder. And he's experienced, among other symptoms, paranoia, suicidal thoughts, hopelessness, hallucinations.
He's also suffered from PTSD. We understand that. We know that he served the country, but he fired several shots and he got 12 years.
Yes, Your Honor, and I'm not here to downplay the seriousness of the crime, of course, and Mr. Cruz understands that it is a serious crime, and which is why we're asking for a modest reduction here. 12 years is, in our view, still an excessive sentence for a serious crime, but one in which no one was hurt, and so we are seeking to just modestly reduce the sentence in light of the other circumstances.
Thank you, counsel. You have time, rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the court. Bridget White for the people.
Now,
Defendant,
counsel, just to get one thing out of the way, you're not defending the appeal waiver, correct?
that's right, we're not relying on the appeal waiver in this case. However, the people respectfully submit that the sentence was completely fair and
There is a
appropriate.
view here is they're not considering that the defendant was already sentenced to 9 years for the Queen's crime, and since the sentences are running concurrent, that for this attempted murder, the actual punishment, the actual new punishment imposed on the defendant is 3 years, right?
3 years beyond what he already had received for the Queen's conviction.
Because he was in for 9 years already.
That's right. And so the actual sentencing exposure, had the judge not found those mitigating factors, would have been 34 years. Here, the 3 in addition to the 9 that he already received for the Queen's case, and as Your Honors have
And
noted, is serious.
absent finding mitigation, the sentences were supposed to be consecutive, right?
That's right, Your Honor. So it's our position that the sentencing court fully accounted for all of the mitigating factors that are present here. Although serious, they were fully outlined in the pre-pleading memorandum, and the sentencing court explicitly invoked them as the reason why concurrent sentences were allowed. So if Your Honors have no further questions.
Mr. Cruz's military service and the fact that he was seriously injured both physically and psychologically as a result of that service, were those factors taken into sufficient consideration?
Then the fact that his criminal history is not lengthy, he only had one other felony conviction.
Yes, so all this information was before the sentencing court, and specifically, Justice Bybin said that these factors that were outlined in the pre-pleading memorandum, which was extensive and listed each of the factors, including the military history, the mental illness, the traumatic childhood, those were explicitly the reason why she found that concurrent sentences could even be within her discretion, as otherwise these would be required by law to run consecutively. So if Your Honors have no further questions, we ask that you affirm.
Thank you, counsel.
Thank you.
Just very briefly, Your Honors, we acknowledge, of course, again, the seriousness of the crime and that many of these circumstances were considered by the sentencing judge, and take Your Honor's point about the 3 years, and still just want to point out that a modest reduction could still result in a lengthy sentence that Mr.
Counsel, what modest reduction are you asking for? The 5 plus 2.5? From the 12 and the 5?
Your Honor, today we're asking for a sentencing reduction of 1 to 2 years.
Of how many years, counsel? I'm sorry.
A reduction of 1 to 2 years.
Put the microphone a little closer.
A reduction of 1 to 2 years. And we think that such a sentence would still, of 10 to 11 years, would still reflect the seriousness of the crime, but give the message that Mr. Cruz still has the opportunity on the other side of his incarceration to make something more positive with his life. Thank you.
Thank you, counsel. Thank you both. (513) West 26 v. George Billis Galleries. Please.
May it please the court. My name is Jameson Davies for the City of New York. This court should reverse that portion of Supreme Court's decision holding the city's personal guarantee law unconstitutional. The pandemic-era guarantee law was a reasonably tailored measure that helped to
Federal
avoid...
court certainly seems to have had the outlook that the law is unconstitutional. Is that not so?
I'm sorry?
The Second Circuit certainly seems to have had the outlook. The federal courts on this seems to have had the outlook that the statute is not constitutional, right?
Well, two responses there, Your Honor. First, the Second Circuit decision that my opponent relies on mostly was just a decision that the case could proceed past the motion to dismiss stage. It wasn't a ruling on the ultimate merits. The district court did eventually find the law unconstitutional, but that decision was vacated due to lack of subject matter jurisdiction. But I think when you say the federal courts, that's
Did you
actually...
attack that finding of unconstitutionality when you sought to set aside the district court decision?
We did attack, we said the court never had any jurisdiction to make that finding, and we also moved in bank in the second
You didn't
circuit.
take on the finding of unconstitutionality, did you?
We in the district court, we disputed, even applying the Melendez framework, we disputed that we've argued that the law was constitutional. Once we had got to the Second Circuit, we thought that the jurisdictional argument was a predicate that we couldn't even reach the issue of the merits. But turning to the other point where you said the federal courts, I think it's important to note that the two-judge majority decision in the Second Circuit is not the federal court's only reasoning here, and this court can follow federal courts to the extent they're persuasive. We argue that the dissent and the Ninth Circuit and all the other circuits who have upheld the U.S. Supreme Court's deferential standard and contracts clause cases are better.
Since the Melendez line of cases, there have been a number of cases in the lower courts, is that right?
There have been a few, yes.
Have you won any?
We have, I don't know that we've won, it's very difficult to say because each kind of law is very distinct. There's one that I think we won a motion to dismiss on a contracts clause case involving DoorDash. I think one, we lost the motion to dismiss, but it's continuing forward. But setting even all that aside, I think this court doesn't need to even go that far because, as we argue in our brief, and as the respondents never addressed, even applying the Melendez factors, the law is constitutional. They forfeited their arguments on that score. They never argue that our arguments about the application of Melendez in this case are incorrect in any way. So I think this court can say, even assuming that the Melendez framework is correct, which we don't agree with, but I don't think the court even needs to reach that question, you can say, assuming that's correct, this law satisfies the factors that were outlined in Melendez.
Did Supreme Court impermissibly put the burden on the city and the other defendants?
I believe so, Your Honor. As we point out, and as the respondents don't dispute, the burden of proving a law is unconstitutional falls on the person challenging that law or the party challenging that law, and it's a very heavy burden. And I think the court incorrectly put the burden on us to prove that the law was unconstitutional.
But just for a second, just to push back on that a little bit, when we remanded to the Supreme Court in this case, we did say in light of Melendez 3, right? And by Melendez 3, it seemed like the burden had already been placed upon the city and the Billis defendants.
I think, in light of Melendez 3, I don't think that it places. I don't think it changes the burden. I think that just
More so that that the initial burden, the prima facie case was made out, and so therefore the burden shifted to you two.
I don't think that's
Is
quite.
that a fair inference?
I don't think that's quite a fair inference because the city had never even had a chance to make arguments in the case or about the burden or about anything else at that point. It hadn't been notified as required by the CPLR. We hadn't been intervened as a party. We hadn't even put the legislative record into the case until after remand. So I think it was just a very early stage before the city got the chance to make the arguments about either the framework that should be applied or the underlying scope of the challenge.
With respect to the reasonableness and appropriateness of the guarantee law, what should we make of the fact that the law didn't merely delay or diminish the guarantor's obligation for the window period, it eliminated it. And so it's not temporary in one sense, it is permanent with respect to the window period covered by the guarantee law.
Sure. A couple points, if I may. I know I'm over my time.
Please, go ahead.
So first, I think, although within that period, those obligations are extinguished. One, it's only for defaults within that period, so it is still temporally limited. Two, it's not, unlike the mortgage cases, it's not an existing obligation. It's an obligation that could potentially come into effect later on because it requires the breach of an underlying lease. And third, I think on the balancing of economic factors, there's a couple points as well. They can still come after the commercial lessor. They can retain security deposits, which in commercial leases are usually 6 to 12 months worth and can be tens to hundreds of thousands of dollars. We point this out in our brief. Look at page 1005 of the record. There's a security deposit for $110,000 that they can keep, and they can retain possession of the premises.
While you're still up there, I know the red light is on. Was there any empirical evidence presented by the respondents that in lease cases, they frequently can't go after the lessee because they're a paper corporation that has no assets, and therefore they rely on these good guy guarantees to get paid, But was there any evidence of that presented?
I don't believe they've presented any empirical evidence. I mean, the part of the sort of the function of the market is that the companies do have less assets, so that's why these personal guarantees were signed in large part. But it also was never the case that they contemplated that the businesses would be forced to close by government mandate. And it's also the case that the commercial landlords retain the shield of limited liability, whereas the personal guarantors do not.
No, it's, okay, thank you very much. You have time, you don't have time in rebuttal, actually.
Thank you, Your Honors. My name is James Marsh. I'm representing the two appellants, the George Billis Galleries and George Billis individually. Actually, George Billis individually is really the only party at risk before the court today. There are two things that I would like to clarify. They were in the record on appeal and they were in the brief referred to, but they kind of got confused because the plaintiff respondent, basically said, well, we had a lease that ran until August of 2025. They didn't. They had a lease that they had amended a number of years ago.
Became a month, your people became a month-to-month tenants.
And they became a month-to-month tenant. So you have that as an issue. The second thing, they treated George Billis's guarantee as if it was a full commercial guarantee. It wasn't. It had the good guy provision in it, which basically said if you do certain things and you vacate the premises, which the landlord did, which the tenant did, the liability goes away anyway. So in some sense, I think you could argue that this appeal has become moot by that fact. I know we have to try the trial court eventually, but as to the constitutionality of the statute, and they're cited in the city's briefs and in our briefs, there are a number of U.S. Supreme Court cases that deal with the fact that the legislature can, if it follows certain procedures, nullify all the portions of a contract. We would submit this is a case where it should be done because George Billis was in the art gallery business. You can't sell artwork if you can't show it. He was forced to close down his gallery by the action of New York State.
I mean, I think what we're struggling with, if there's a three-part test that the U.S. Supreme Court has articulated, what I struggle with anyway is whether the legitimate public purpose has, once it's been identified, whether the adjustment, I'm reading, so, whether the adjustment rights and responsibilities of the contracting parties is based on reasonable conditions and is of a character appropriate to the public purpose. So in other words, meeting the means and ends. And did that happen here?
I believe so. I believe if you take a look at the record on appeal that we filed jointly, I think it ended up being like, was it 12 volumes of the evidence that was presented to the Corporation Council to show why this was reasonable under the circumstances.
I think you mean the city council, right?
I'm sorry, the city council. I'm a Long Island boy, sorry about that. The second thing that I would want to point out is some of the older Supreme Court cases, but one in particular by Justice Frankfurter, basically talked to the fact that you can't do away, the Constitution couldn't do away with the police powers of the state. And if there was any point in time where there should be implied in a contract that the government has the right to fix a problem that the government caused, all right, this is it. To cause a guarantor of a small company to basically be bankrupted is really not fair. And if I can just
Well, the one who relies on the guarantee may also be getting bankrupted. I mean, there's an assumption that whoever is relying on the guarantee is necessarily someone who's got limitless assets. I mean, they may be a small property owner too.
Your Honor, I understand that, but there are 2 points. We're talking about, at most, an 18-month period. We're not talking about doing away with the guarantee forever. Now, as it turns out, because of certain elections that the plaintiff made and the trial court, parts of the guarantee were in fact dismissed, and that was affirmed by this court in its last decision. And now they're trying to weasel it back in again, but that's a different issue. And the second thing that I think is important to recognize is that, sorry, I lost my train of thought. So at this point, since the red light's on, unless somebody else has a question,
Any other
I'll
questions?
trust the court in reading the briefs. I think the briefs adequately touched on everything.
Thank you, counsel. Thank you
Okay,
both.
thank you.
Seguencia v. the Hudson Companies. Please.
May it please the court, my name is Michael Manorel, and I represent the third-party defendants, appellants, respondents, New York Hoist, and NYC Crane Hoist and Rigging.
Can you put the microphone a little closer to your mouth? Thank you.
Sorry. This is an appeal from a decision in order of Judge Moyne dated September 5th, 2024. That decision granted plaintiff's motion for summary judgment on Labor Law 240 sub 1 and denied our motion to dismiss all claims and cross-claims against my clients and for common law indemnification against
We're
B&V
familiar with the
contracting. Yes.
dispositions. But counsel, let me ask you this, because B&V argues that there's evidence that one of your workers, maybe the plaintiff himself, might have knocked over the frames themselves. Mr. Abruzzese, I'm mispronouncing his name, I think Abruzzese from B&V, said, or maybe hypothesized, that that happened. How do you respond to that?
There is not a shred of evidence of that. That is purely fabricated by counsel. There is actually, that is directly contradicted by Mr. Abruzzese. Plaintiff didn't know what hit him, but he was shown a photograph. He couldn't articulate what hit him, but he was shown a photograph of the door frames that fell on him. He pointed to the photograph, was shown at deposition. He said, "That's what hit me." Okay, and Frustacci, the general contractor's foreman, Steve Fursa, was shown that same photograph and said, "Those are B&V's door frames." Mr. Abruzzese was shown that same photograph and said, "Those are our door frames."
Right, but didn't he also say that other trades at the work site would move them around as necessary?
He never said that, actually. He said his testimony is that they unloaded the door frames from the truck onto a cart. The frames were then placed by B&V at the premises, and he testified that he was unaware of anyone other than B&V placing the door frames, and he was unaware of anyone other than B&V moving the door frames. That is mere conjecture on the part of B&V's counsel. There is absolutely nothing whatsoever in the record. And
Also, didn't he also say that as the work progressed, another trade might move the store door frames if the frames were in the way of that trade's work assignment?
that was supposition on his part, but he had no knowledge of that actually happening. And Daniel Moliterno of New York Hoist has submitted an affidavit saying that New York Hoist had nothing to do with those door frames. They didn't design them, fabricate them, unload them, place them, and no one ever touched them. Plaintiff denied ever touching the door frames. And again, Mr. Abruzzese testified as to B&V having involvement with the door frames. The only testimony in this case is that B&V was solely responsible for placing the door frames. And there's no evidence that once they were placed by B&V, they were ever moved. There was room for plaintiff to perform his work without moving the door frames. There's no indication that plaintiff did that. Plaintiff directly denies doing that. And with regard to the claim that somehow B&V, the Judge Moyne made some claim or thought out loud perhaps that that my clients should have moved the door frames, and that in light of how job sites work in the city is absolutely untenable. First of all, the Frustacci, as the general contractor, was responsible for the safety and work environment. The fact that there's a contract provision providing general duty for safety to my client does not confer any authority.
Counsel, you have time to rebuttal for the remainder.
Okay, that's fine.
My name is Kevin Brennan. I represent all the defendants, and they're defendants and respondents and appellants both. But I'd like to devote my time just to the appeal by two of those parties, the general contractor and the owner, Frustacci and Athena Housing, and just direct my remarks to the request that you modify the order below to deny the award of summary judgment to the plaintiff. And the basis for that is that if the evidence is viewed in the light most favorably to those defendants, a reasonable jury could
You're sort of relying on, as I understand it, counsel, you're kind of relying on falsus and uno, right? You're saying that the plaintiff may have not told the truth about the accident, and that's shown by the hospital record. Correct? I mean, that's your argument, roughly. And so therefore, a jury should evaluate his credibility, or am I mistaken?
No, when you say rely, I flinch at the way it's phrased. But yes, that falsus in uno is an important part of my argument, because under the law, the reason a reasonable jury could disbelieve plaintiff is because there's admissible evidence that he willfully testified falsely at both of his depositions.
Okay, is that the hospital record, though? Because it seems to me there are infirmities with respect to the admissibility of the hospital record. So are you relying solely on the hospital record?
No, I'm not relying solely on the hospital record. The most important part is that twice, at two separate depositions, he testified that he was disabled by the accident and he had been unable to do any work since. And then he was confronted with evidence and confronted with evidence that he had worked after leaving his employer. He worked for only 2 weeks.
Does that affect liability? Does
sorry.
that affect the liability? Does that fact that he has made those claims with regard to his work history affect the liability?
Yes, but credibility affects both liability and damages. It's offered, and I cite it, not because in and of itself it changes the liability, but because the liability depends on his truthfulness. And there's evidence really I don't think reasonably can be refuted that he testified falsely about after he stopped 2 weeks after the accident working for his then employer. He never worked again because of the pain and he's disabled.
Don't we have an eyewitness to this accident?
Yeah, that's a different issue. There's an eyewitness to this accident who was not disclosed by plaintiff, despite plaintiff having obtained an affidavit from that eyewitness.
His name is Freddie Guarton, correct?
Yes, that's correct.
Okay, and Freddie G is identified in the accident report that was filled out immediately thereafter. Also, one of your clients is the general contractor, so couldn't he have located what Freddie G was on the work site that day?
It's in the record, and it's in the brief, that Freddie G was an employee of Mike's client, the same New York City, New York Crane, one of those two Crane defendants, and the same employer that plaintiff had. The incident report produced at plaintiff's first deposition by New York, the employer.
What you want is for us to just discount the evidence that the frames fell upon the plaintiff because he lied on other occasions, even though there isn't really any evidence putting into question that the door frames fell on him.
Oh, I think there is a question whether the door frames actually fell on him, because he's the source of the information that says the door frames fell on me. The only other source of the information is Freddie Gartin's affidavit, but the plaintiff was the only person who knew his last name and who knew where he was, and it wasn't disclosed.
Hey, counsel, you have time in rebuttal. Thank you.
Thank you.
Afternoon, Your Honors. Joshua Block on behalf of the plaintiff respondent. This is a very straightforward labor law 240.
Is there any evidence that the doors didn't fall on him?
No, there's no evidence at all. In fact, as Your Honors recognized, on page 914 is the affidavit of, I'm going to just call him Freddie G, because otherwise I'd butcher his last name, where he says he saw the accident happen. What he says is, as I was staring at the toolbox, I saw several heavy metal frames that were laying against the wall fall on top of the plaintiff.
And he went further and said that the plaintiff became unconscious, correct?
He did, yes. So as to this Freddie...
But this is one question that is not answered in the record, I don't think, is how did they fall? I think B&V, somebody cited Newton's first law of physics, which is not legal authority I'm that familiar with. But, you know, the question is, how did they topple onto the plaintiff?
Sure, and I know there's the argument of common sense says they would slide out, but just because some objects fall by sliding, other objects fall by toppling. We don't know the exact mechanism. I could speculate that this was open to the wind because it was open to the wind. That caused these to fall. I don't know, but that's not our burden. What we know is that they did fall, and we know that other objects fall in this manner. We cited a number of other cases where objects were leaned against walls and other similar objects that toppled over from the top to the bottom in the same way. There's the Lucas case, which is stacks of 8 to 10 pieces of plexiglass that were resting against a wall. There's the Gregorian case, which is the 3 to 4 foot tall fire pump. That's the Guerta case.
Something about pipes seems sort of more inherently unstable than these very heavy frames, but I take the point. I mean, you do have that authority.
Yeah. If I could turn back to the Freddie G, not only was he discussed at plaintiff's deposition, not only was he contained in the accident report, there was also a notice of deposition from September of 2023, which predated, from January of 2023, which predated plaintiff's September motion, and it very far surpassed, was much earlier than the November oppositions. Beyond that, this wasn't even an issue that was raised in the appellate's briefs. Not really even addressed in the reply briefs.
What is the court supposed to do with the fact that there is this serious discrepancy within plaintiff's testimony about his condition after the accident? I mean, how does that factor into his claim that these frames fell upon him?
Well, I think as Justice O'Neill-Levy pointed out, that goes to damages. It doesn't go to liability. There's no evidence except for these metal frames fell on him. There's no evidence except for this is a pure 240 case.
But the only evidence, really the evidence that they fell on him primarily comes from the plaintiff. He's got this other witness who seems to be someone that's not, the defendants are not able to locate. What do we do with the fact that there is this clear-cut discrepancy in his testimony? I mean, to say that it goes to damages, why doesn't it go to how did the accident happen?
Because there's other cases where there's much greater discrepancies. For example, there's cases where one person says it was dropped, another tool was dropped, another person says it was fell, that was kicked, another person says it just came off. There's one person.
That's an inconsistency between two separate witnesses. We're talking about the credibility of one particular witness, a party here.
Yes. But what that goes to is
there has to be a non-negligent explanation, and there's not. What this is these are minor inconsistencies that happened between depositions that happened over the course of multiple years. And so what that does is that brings this case within this court's Robinson case, where this court said plaintiff should not be denied summary judgment due to minor immaterial inconsistencies in her testimony, within the plaintiff's own testimony. And so I think that's the controlling case on that issue, Your Honor.
Thank you, counsel.
Thank you.
Good afternoon, and may it please the court. Chirag Satsangi from Galbatucci Clark for the second third-party respondent of B&V Contracting. Your Honor, our first argument is that New York Crane is seeking common law indemnity from B&V without having ruled out their own negligence, and that is their burden on summary judgment. New York Crane has failed to demonstrate that they weren't negligent from the fact that immediately after the alleged accident, there was the superintendent from the general contractor who came to the scene after the incident and saw a hoist gate on the ground where the alleged incident happened, while the door frames were still propped up. So they did not fully address that issue. Our second point, Your Honor, is that Labor Law 240 claim is that there's multiple issues of fact existing regarding severally materially conflicting versions of what happened. First and foremost, there is the plaintiff has asserted that a door frame had failed. He also stated that metal piece he was working on has hit him, and there's also the hoist gate that was found on the ground. And a lot of that was not really determined or really relied on, if you will. And this is why, hence why we believe that they should not be held negligent at this point.
Thank you, counsel. Is there anything you wish to add?
Sorry?
I'm not looking for anything, but you have more time. Do you wish to add anything?
No, thank you for the time, Your Honor.
Thank you, counsel.
Appreciate it.
Just briefly here, I heard no arguments from anyone regarding our position that the contractual indemnification claims against my clients should be dismissed. There's indeed no contract at all between B&V and my clients, so that Judge Moyne erred in failing to dismiss that.
Is it your position that the indemnification clause requires some showing of fault, not necessarily negligence on the part of your client?
Absolutely. It's the first contract, the 41918 contract, in the record at page 153 to 161, requires that the accident be caused in whole or in part.
So it's not one of those arising out of indemnification
Correct.
clauses, yeah.
And the other indemnification agreement dated 6/26/18, 225 and 226 of the record, requires that the accident be resulting from the acts, omissions, breach, or default of the contractor. That is not the case here. In addition, the owners in GC do not dispute New York Crane and NYC Hoist's right to dismissal of common law claims. Again, that was not disputed in the court below either. Judge Moyne should have dismissed that. With regard to what counsel for B&V just said, Mr. Fursa, who's the foreman of the general contractor, came to the site, saw a gate lying on the floor, and assumed that that's what struck plaintiff. He testified, and this is on page 1062 of the record, he testified that his prior assumption that the gate is what was involved in the accident was, quote, pure speculation, end quote. There's nothing there. And again, plaintiff was shown the photograph of the door frame, identified that as what hit him, and it was confirmed by everyone else. And there's no question that those door frames depicted in the photograph identified by plaintiff were B&V's door frame.
Thank you, counsel.
Thank you.
I'd like to say three things. One is, Your Honor, you asked about the admissibility of the hospital record. It's definitely admissible because we took the deposition of...
Uncertified, not germane to treatment. We don't know if he was the informant. Also, he's a Spanish speaker. And there was no translator.
There's a
shown.
deposition in the record. We subpoenaed the native Spanish speaker physician's assistant who entered that into the record. And she testified at deposition and was cross-examined about the conversation that she had with him. So that's an admission. And then it doesn't matter really whether the record is certified or not. She testified, I was working that day, I'm a physician's assistant, he came in, he told me this, blah, 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 and I made this record.
What was that person's name, counsel?
Her last name is Mercier-Munoz, and it's definitely an exhibit in the record.
Thank you.
The second thing is, the point about, Your Honor, the credibility just affects damages. That pattern jury instruction and the law, the common law that it's based on is basically, if someone takes an oath to tell the truth and the jury finds that they willfully testified falsely, which you can't really dispute that he did here, then the jury can disregard
Counsel, we've all
of
been
that
trial
witness's
lawyers. I mean, all been trial lawyers and judges. We know the instructions.
Okay,
Don't worry.
then what was the last? Oh, the last point has to do with the Freddie G affidavit. The sequence is that the preliminary conference order, which is in the record, was August 6th of 2019, and it said to disclose witnesses, which is routine. That the first deposition of plaintiffs was February 5 of 2021, where there's talk about Freddie G. And it's in the record that after that, Freddie G's employer wrote and said, we have no knowledge who employed plaintiff, and on our report, it says Freddie G. We have no knowledge who Freddie G is. Then Robert Nuala was the foreman, the other person. And my firm, it's in the record, hired an investigator, went out, served Robert Nuala with a subpoena at his home. He disregarded the subpoena. We didn't try to find him and arrest him for contempt because he was the only other witness other than plaintiff.
Thank you, counsel.
I mean,
counsel, the red light's
Just
on.
before you go,
plaintiff serves a deposition notice
Counsel.
for Freddie G.
Counsel.
just
Oh,
before
time's
you go,
up? Okay.
Mrs. Friedman
tell
has a
us
question.
again what you say the physician's
Oh,
assistant.
you have a,
What did the physician's assistant testify to at the deposition?
what did?
The physician's assistant, you said you
Oh, the
subpoenaed.
physician's assistant testified to the record. The physician's assistant says, I met with him, I talked to him, and what's in the record is what he told me. And we spoke in Spanish, and Spanish was my original language.
Thank you, counsel. Thank you all.
Thank you.
Adagio v. Abdu Rahman Sai.
Good afternoon, Your Honors. Bruce H. Letterman for the appellants. The lower court erred as a matter of law in awarding a default judgment of over $700,000 because no answer was due. No answer was due because CPLR 3211F sets the time to file an answer as 10 days after service of notice of entry. There is no question this court's order from 2022 has never, to this day, been served with notice of entry. The lower court erroneously held that the filing by this court's clerk, NICEF, constituted service with notice of entry. That is simply wrong for a variety of reasons. First, the enabling regulations that allow NICEF say right in them at 22 New York CRR 2025BH, posting by the clerk of the court shall not constitute service of notice of entry by any party. This court made that point in the case Fazio versus Costco, which is cited in my brief. Ironically, my learned colleague posted online yesterday to this court additional authority, a case by our friends across the river in the Second Department, U.S.
Quevedo
Bank
case.
versus Quevedo,
Right.
which drew the exact distinction I'm talking about. They said in that case that a court order which said this order is effective 10 days after notice of the entry of this order is different than service of notice of entry by a party. That case is exactly what I'm saying, and thank you for finding it. I didn't have it. Here you have a statute, CPLR 3211F, which sets the time based on service of notice of entry. That's a very specific thing. If that was right, it would end practice in the state and this court because the time to appeal is measured from service of notice of entry. And otherwise, if they were right, if the court below were right, probably half the appeals this court hears are jurisdictionally defective. I'll just very quickly make two additional points. One, if for any reason the court disagrees, as a matter of discretion, this court should substitute its discretion. This case has been fought tooth and nail. This is the third appeal. Judge Adams keeps granting default judgments for whatever reason, but my client should be entitled to be heard on the merits. I'll end by saying the vast majority of the opposition is an overwhelming plea that they think my client's a fraudster. I will not go into the facts, except to say my client has a very different view that he wants to say to a jury. He has never been allowed. Every time we go back to Judge Adams, who I like a lot, she says, she listens to the merits and says, your client's a fraudster, I'm granting a judgment. She did done it, it was reversed. She did it again. With all respect to her, service of notice of entry is something the plaintiff could have done. When we were here the last time when I argued it, we had this exact discussion. We went back, and instead of serving notice of entry, which would have triggered the time to appeal, they moved for a default. I immediately filed an answer. 4 months later, Judge Adams said, well, your answer was 2 years too late. That is an abuse of discretion. I would urge the court not to listen to an argument about the merits. There is a different side to that story that's not relevant here. The only thing relevant is that a default judgment for $700,000 piercing the corporate veil should not have been entered as a matter of law. Thank you.
Thank you, counsel.
Bernadette Panzella for plaintiff respondent Adago. I respectfully submit to this court that this court has a lot of rules. I followed those rules, and those rules say that when the clerk of this court serves a notice of entry, uploads it to the to NYSEF, it's considered, and I specifically cited that rule in my brief, and I would call the court's attention to that. As far as, I'd like to go back for a second, though. I know we only have 2 minutes, so I would like to go back for a second to counsel doesn't want to discuss the merits of this case and seems to, well, make some comments about
Counsel, but in our last time you were here, we remitted for the purpose of discussing the merits of the case.
Yes.
Whether or not the MOU was obtained via fraud.
Yes.
That didn't happen.
Yes, Your Honor, it did. Justice Adams had an extensive hearing on July 16th.
She didn't reach the merits, though.
Oh, yes, she did, Your Honor, and we have a, not to...
No, I mean, but she dismissed it on a default motion. That's what we're here for.
No, before that, there have been two
If it's on the merits, why was there a default order?
There would be, no, this court sent this back the first time. Judge
I'm
Love-
talking about the second time, counsel, when she dismissed it on default, dismissed the case.
That's this appeal.
Yes, exactly. That's why we're talking about it.
Okay, so we had a hearing on that on August 17th, 2024. Prior to that, Justice Adams had a hearing on remand from this court on June 16th. The MOU is defective on its face, which I go into in my brief rather extensively. The MOU, which they're relying on in this case, says that you are supposed to have other documents which would have given Mr. Adago certain rights to become a shareholder that would have guaranteed him his money returned if it wasn't invested. And
Counsel,
those,
we understand your arguments about why the MOU was invalid or that was part of a fraud. We understand those arguments, but the problem is that Mr. Tsai hasn't been given a chance to provide his counter-arguments yet to the court, which is what we remitted the case for last time.
he did give his counter arguments in court through 3 different lawyers now, before Justice Adams, and in 2 hearings on July 16 and June 16.
Counsel, if we remitted it
and
last
August
time you were
17th.
here, if we
I'm sorry, I
remitted
didn't hear that,
we did remit it last time you were here for the purpose, the very purpose of finding out if the MOU was permeated by fraud. Then, isn't that what Judge Adams should have done after we remitted it the last time? Not whatever she did before, because apparently we found that to be inadequate.
I'm sorry, Your Honor. I was present at both of the hearings. The hearings consisted of all of the bank records, the certified subpoenaed bank records that showed the fraud.
What prompted
So
that
why
hearing?
didn't she decide that?
What prompted that hearing?
What prompted that hearing is the remitter from this court the first time.
Okay, and so why then, I think this goes back to something Justice Friedman mentioned earlier, why then the motion for a default judgment? If a
Because
hearing on
this
the
court
merits?
issued a second order which specifically pointed out that at the time of this court's second order in May 2023, that the defendant was already in default by 22 days from the time of the first hearing, back in June, the year before.
The service issue with regard to our case, Fazio versus Costco.
Yes, Your Honor, that has to do with the Supreme Court case, just like if I file a notice of appeal, it has to be filed in the Supreme Court on NYSEF within 30 days of notice of entry of that order. This court has different rules. I'm sorry.
So, Counsel, your argument is that the CPLR is nullified somehow?
No, I agree with Justice Adams when she said that this court's rules, which are very specific and very particular, supersede the CPLR.
Good luck.
I would just also,
Counsel, it's okay. Thank you very much.
Rule is not going to supersede a statute, even
Absolutely
assuming there's
not.
an inconsistency.
Okay, do you want some more time, Mr. Letterman?
Just very briefly, I think the court understands the issue of the Fazio case. With respect to the hearings that she's talking about, the first hearing was not a hearing. The first hearing, and this was why it was reversed the first time, was counsel for Mr. Adago made representations, made an oral application for summary judgment without a motion and recited the facts. That was reversed because that's not a hearing, and this court, I don't think any of you were on it when I argued it, said there's no such thing as an oral motion for summary judgment without evidence from the parties. That was not a hearing. The second hearing, we were arguing with there was no testimony. I was arguing with Judge Adams, who kind of tongue-in-cheek, when I addressed the issue of the appellate division rules don't overrule the CPLR, and she, very friendly, I'm not criticizing her, she goes, oh, Mr. Letterman, so this is in the record, so now you're an expert on the CPLR? I don't know what that meant, but I think this court understands. This court's rule doesn't say that the posting by the clerk is service by a party with notice of entry. All it says is shall be deemed service on the parties. And of course, NYSEF, anytime you post, is service on the parties, which is different than the 15 specific examples. If you if you search on Westlaw the exact term, service of notice of entry, you find out 15 specific things in the CPLR require. One of them is timely notice.
Thank you, counsel. Thank you
That's
both.
it. Thank you, Your Honors.
Park Row 23, Vijiha, Justice Rosado is recused on this case.
Ari Grun for the appellant. May it please the court. I'm going to jump right to the SCRs that are at the heart of this case, the special eligibility requirements. It's obvious that these requirements have no rational relationship to the residential part of this building for several reasons. First of all, the residential part was not part of the ICAP application, not eligible for ICAP. Any money spent on the residential part is excluded from the minimum required expenditure, another ICAP eligibility criteria. And in general, ICAP is a commercially focused program and has nothing to do with the construction of residential premises. Even more specifically, though, looking at the SERs themselves, in order, they deal with floor height, fiber optic telecommunication wiring, square footage, the placement of structural columns, electrical capacity of 6 watts per net square foot, a very common commercial standard, emergency backup power sufficient to accommodate it. These SERs are clearly designed solely to pertain to the construction of commercial premises.
Now, building or structure is not defined, right?
It is not defined anywhere in the statute. What
So why is Department of Finance's interpretation irrational? I mean, again, you have to basically show that not only is your interpretation plausible, but it's the only reasonable construction.
Well, on that point, first of all, I would refer this court again to its decision in matter of CDL in 2003. That case involved ISIP, not ICAP, but it's the immediate predecessor statute. There's essentially not much difference. And in that case, the DOF argued that the same thing, they should be entitled to deference. Their interpretation of, in that case, it was the term physically and functionally integrated, an undefined term. And DOF said, we're entitled to deference, we're a taxing authority. The Supreme Court agreed, this court reversed. This court said, no, we're looking at the clear purpose of the statute. The legislature intended this to be a tax benefit program. If you qualify, you qualify. And DOF's arbitrary interpretation of that term was just an artificial bar to the receipt of benefits. So we're not going to defer to them. And was the developer's interpretation in that case the only plausible definition of physically and functionally integrated? I mean, those terms are very vague, but this court looked at the legislative purpose, the intent of the statute, and the court should do the same here. And if it does, and DOF doesn't really want this court to do so because it's clear that this is completely arbitrary and irrational. The legislature would not have put in these requirements, allowed mixed-use buildings to apply on a tax lot basis. There's no dispute about that. So the commercial part of this building met all the requirements. There's no dispute about that. There's also no dispute that, in general, commercial properties can apply on a tax lot basis, meaning they can get ICAP even if the rest of the building does not. The only dispute is, that being the case, whether these SERs should then apply to the entire building, which is not part of the application. There's no rational explanation for why the legislature would do that. And so, again, I'm short on time, but the appellant did everything it was supposed to do here to obtain the ICAP benefit. It built this commercial premises in Lower Manhattan, 62,000 square feet of office and retail space. It met the SERs. It spent $15 million. It created permanent jobs for city residents. The DOF's interpretation of this term, building or structure, is just artificially denying them the benefit that the legislature intended to confer on them. And so, for that reason, the court should reverse. I would just add one final thing. I have a moment left. That there's also this issue that the appellant went to the DOF beforehand and asked them to confirm in writing that this was the case, and they did. That the SERs would only apply to the commercial part of the building.
There you run up against the general prohibition against estoppel against a government agency. So you can use your rebuttal for that time, perhaps. We can talk about it at greater length. Thank you, Judge.
May it please the court, John DeBaptiste on behalf of the Corporation Council of the City of New York, representing respondent, Commissioner of Finance of the City of New York. Your Honors, the court should affirm the lower court's decision that found Finance's determination rational and reasonable. It's well established that the clearest indicator of legislative intent is the statutory text itself and giving effect to the plain language of the statute. Although building or structure is not defined within the entire ICAP statute, as the lower court correctly found, the plain language, building or structure, refers to the entire physical edifice. That's backed by Black's Law Dictionary, which the lower court came to its own conclusion by citing that.
What about matter of CDL? I know it was applying a slightly different statute, adjacent statute, but how is it distinguishable?
Yes, Your Honor. So matter of CDL is distinguishable. First, because the terms at issue there were physically and functionally integrated, and in that case, respondents actually ignored the plain meaning of the text, and those words were very evidence-specific, and respondents in that case not only ignored the plain meaning, but they also ignored the evidence of physical integration. Additionally, the court in that case had focused on the fact that respondents had previously treated the hotel and theater as a single entity, which went against what they were arguing. In this case, finance actually, read it the way the lower court agrees is the plain language, and it is actually petitioner that is arguing, for a definition that is found nowhere in the ICAP statute. The ICAP statute, from beginning to end, wherever building or structure appears, is referring to the entire physical edifice, and the definition section, which is the first part of the entire statute, goes through commercial property, industrial property, mixed-use property. In all those definitions, it says building or structure or portion thereof.
You make that point very well in your brief. Do you want to talk in anticipation of your opponent's argument about the estoppel argument, about Ms. Chan's statements to them? Why couldn't they rely on those statements?
Yes, Your Honor. So it's unfortunate that Finance's employee made a mistake in the interpretation. However, as the lower court found, the wording of the emails was unclear and confusing enough that petitioner drew two opposite conclusions. But as the lower court correctly noted, erroneous statements by an employee of finance cannot bind finance to an erroneous interpretation. And this court itself has said that estoppel may not be invoked against a municipal agency to prevent it from discharging its statutory duties or to validate unlawful acts or create rights not entitled to a petitioner, such as in this case. Petitioner was a sophisticated real estate developer. The fact that the wording was unclear, that they drew two opposite conclusions, should have made them inquire with finance, such as getting a letter ruling, etc. They did not. Thank you, Your Honors.
Thank you, counsel.
If I could very briefly touch on one point before the estoppel issue. The DOF's arguing that the term building or structure, must mean the entire building. But they themselves issued a rule, an ICAP rule, in 3610 of the ICAP rules. It's a very specific context involving the retail use limitation. And in that one context, they felt the need to say, in this context, building or structure means the entire building. Well, if that's the case, if building or structure always meant the entire building, there would be no reason to issue that rule. So it can mean something else. Even by the dictionary definition, the word structure, and it's obscure, but is any construction or piece of work composed of parts joined together in some definite manner. It's obscure, but I would submit that the commercial part of the building meets that definition if the lexicography, if the dictionary definition holds sway.
If the legislature wanted to give it meaning other than the plain and common meaning, wouldn't they have provided it in the definitional section that your friend referenced?
They might have. It's not defined. The term building or structure, again, I think it depends on the context. It couldn't mean it couldn't mean the entire building in the context of the SCRs in this case, because of the fact that only the commercial property was the subject of the application. I see I'm out of time, but we didn't get to address the estoppel. I'll rest on my brief on that point.
Thank you, counsel. Thank you both. CS leveraged loan funding.
Good afternoon, Your Honors. May it please the court. My name is Stephen Shepard. I represent the buyer, CS Leveraged Loan Funding, and its agent, Black Diamond Capital Management. CS's case should be remitted for the jury to determine what Bank of America agreed to and whether Bank of America breached that agreement. CS's representative, Auerbach, explained the terms of this trade by telephone to the bank's representative before the trade occurred.
Now, he and Mr. Van Orden had a relationship, right? Hadn't they executed many trades, perhaps, is it hundreds of trades in this manner?
That's correct, Your Honor. Many trades between these, both Bank of America and Black Diamond, and also between these two. And in this trade, Mr. Auerbach explained the terms. He explained what his buyer wanted: to obtain participation interests in the Crown loans. He also explained why his buyer would be eligible to obtain those participation interests, even if its affiliate and agent, Black Diamond, had been named a disqualified institution. He explained that this would be eligible.
Now, the other side says that the reason that they were on the disqualified list was that they were activist investors and Crown was concerned about that. Isn't this sort of an end run around that concern of the lender?
The reason why Black Diamond was put on the list does not appear in the record.
Okay, so that's just a supposition, A. But say it's true, isn't this like just having some new entity named CS? Isn't that just an end run around that concern of the borrower?
I'd put it slightly differently, Your Honor. It's structuring the trade in a way that complies with the strict terms of the credit agreement as it was.
The purchase was going to be done in the name of CS, right?
Yes, Your Honor.
And CS by name is not, you can't tell by its name that it's a disqualified buyer, that it's on the disqualified list.
Exactly so, Your Honor. Now, the lender, if it was concerned about this, could have drafted the definition of disqualified entity differently. At pages 1263 through 1266 of the record, we have the report of our expert on just this point, who has a lot of experience in setting up these syndicated loan trades. When the lender defines disqualified entity, the lender knows it could choose a very broad definition, both the named disqualified entities and any person or entity affiliated with them or known to be affiliated with them. But if the lender did that, the transaction costs on the secondary market for trades like this would be much higher. The loans would be harder to market. That's why definitions are included like the one in this.
Does ordinance seem to start out with the idea, well, yes, we can do the deal with CS?
Excuse me, Your Honor?
Does ordinance start out with the mindset that, we can't do the deal with Black Diamond, but we can do the deal with CS?
Yes, Your Honor. That's exactly what Auerbach.
But he just never actually executes it.
The confirmations, which are generated by Black Diamond and sent to the bank within 5 days after, expressly demonstrate, and they're at page 772 of the record, that the buyer and the principal is CS leveraged loan funding. That same document, the trade confirmations, name Black Diamond in the attention to line. Black Diamond is the agent acting for CS. Those confirmations were never objected to by Bank of America. So under General Obligations Law 5-701(3)(b), those confirmations formed the contract between CS and the bank in October of 2021. Now, for internal reasons,
a separate issue or a related issue, you're also contending the Supreme Court erred in not dismissing BDCM as a counterclaim defendant because of that.
Yes, Your Honor.
It wasn't a party.
That is correct, Your Honor. Exactly right. The trade confirmations control, and that trade confirmation expressly incorporates the standard terms and conditions document, which applies to these trades and is published by the Trade Association, the Loan Syndication and Trading Association. In paragraph 14, it addresses principal agency issues, and it states that whereas here the confirmations are clear about who the principal is, who the buyer is, then the agent, and I quote, shall not be liable. That's at page 728 of the record.
Thank you, counsel. Your time on rebuttal.
Good afternoon, Your Honor. Jeff Reziteritz with A&O Sherman on behalf of Respondent Bank of America. Your Honors, the undisputed evidence shows that on September 29th, 2021, Black Diamond and Bank of America entered into a binding loan contract. That binding loan agreement is captured in the Bloomberg chat That is
Right,
that.
but counsel, what about the phone conversations leading up to that September 29th Bloomberg chat? Doesn't that create, the divergent accounts of those phone conversations, doesn't that create an issue of tribal fact?
It doesn't, Your Honor, because Section 5-701B of New York General Obligation Law states that loan trades do not require a signed written contract, provided that, and this is the key, provided that there's sufficient evidence that a contract has been made. And the statute's clear that sufficient evidence means that there needs to be an electronic communication that shows an agreement was made, and the statute defines what type of electronic communications are valid. Telephone recordings and electronic communications. Here, there is
Doesn't that also
no-
contemplate the possibility that there will be other terms within the ambit of the contract that aren't embodied in that electronic communication, or not?
I mean, here, Your Honor, we have a Bloomberg chat where all the material terms of the trade were agreed to. That's at 529 of the record. You see the communication between Auerbach and Van Orden on September 29, 2021. And immediately after that trade, a trade confirmation is issued that lists Black Diamond as the buyer and B of A as the seller. That's at 1033 of the record.
Is the record conclusive that Bank of America settled the trade as soon as practical?
With regard to the as soon as practicable, if you looked at the standard terms and conditions, which is at 726 of the record, the words as soon as practicable have nothing to do with the settlement of the trade. And it certainly doesn't put an obligation on the seller to settle the trade as soon as practicable. The only place where the words as soon as practical appear is the payment of the amount for the loan from the buyer to the seller. So that would mean that Black Diamond has to pay B of A as soon as practical. That's the only place that appears. Your Honor, so under New York law, back to the general obligation statute, the pre-trade unrecorded telephone calls simply are not valid loan agreements under the contract. The only valid loan agreements are found in the Bloomberg chat.
Well, go ahead. Well, I was just going to say the STC says something about that. The LSCA STC specifically provided that the parties were bound by the terms of any agreement reached by telephone.
No, that's not what the standard terms and conditions say. The standard terms and conditions say that you don't need a written contract. Right. It's just mimicking the general obligation law. You don't need a written contract, but what you do need an electronic communication, either a phone recording or some sort of email or chat or something like that. The only chat that we have is the Bloomberg chat. And in that chat, if you look at that chat at 529 of the record, what you see is Black Diamond reaching out to B of A, asking them to go.
But is it clear that the Bloomberg chat contained all of the terms of the agreement? Sure, they seem to have the essential ingredients of a binding agreement, but did they have all the terms?
The obligation was on Black Diamond if there were other terms that they wanted to be part of the contract to pull that into the Bloomberg chat. What's in the Bloomberg chat is they ask B of A, go out and source this loan and then sell it to us. And what you see is Van Orden coming back and saying, here's the price we can sell it to you. Here's the amount we can sell it to you. Here's the name of the loan that we can sell to you. It's all the material terms of the contract. And Auerbach says, great, let's do it, done. That's the contract. That's what the
I know this would be asking an awful lot in a chat, but there was no integration or merger clause in the Bloomberg chat, right?
Absolutely not. Mr. Auerbach could have said, oh, and by the way, there was this telephone call where X, Y, and Z was agreed to. That doesn't happen. We strongly disagree that these telephone calls happen. And the reason why the statute of fraud is so important is just for this type of situation. We have a Bloomberg chat where all the material terms are agreed to, and then we have one party coming along and saying, oh, there was this other call where we agreed to stuff. No, I'm sorry. There needs to either be a telephone recording or he needs to pull that into the Bloomberg chat, those material terms. Otherwise, we're left with trades where people can just say other things were agreed to.
I asked your opponent the other, when he was up, that Van Orden and Mr. Auerbach had a pattern and practice of doing trades this way, right? They had worked together a great deal, had they not?
They had worked together. And what happened in those prior trades is that B of A and Black Diamond entered into trades either on the phone or in Bloomberg chats. And the trades were then allocated to a sub-fund of Black Diamond. And if that sub-fund...
That's another point, that you never had a deal just with Black Diamond, right? It was always with some entity that was created by Black Diamond.
But it's critical under agency law.
Is that true, though? Am I right about that premise, that it was always Black Diamond not trading in its name, but rather under some other entity that it created for the deal?
I don't know what happened in those trades. If in those trades they came forth and said, listen, we're not trading for Black Diamond, we're trading for X, then yes, the trade would be for X. If they go into a Bloomberg chat and say, I would like you to go source this loan and sell it to us, and they don't mention anyone else, of course it's with Black Diamond. It has to be with Black Diamond. Bank of America cannot put its capital at risk with some entity they've never heard of or don't know the name of. And under agency law, a week after the trade was the first time that we learned about this CS leverage loan entity. For 100 years, courts in New York have held that an agent for an undisclosed principal, both entities are parties to the trade.
No, but see, they're arguing that there's evidence to the contrary. Does that create a triable issue of fact that you did know about CS? Not you, but your client, obviously.
Your Honor, again, the material terms of the trade are in the Bloomberg chat, and that complies with New York, with general obligation
but that
law.
doesn't answer my question. I mean, don't they have some evidence, which you obviously disagree with, but still should perhaps go before a jury, that they did know about, that your client did know about CS's existence? And that
Your Honor, I would encourage you to look at the affirmation that they submitted at Evans. There is no mention of CS leverage loan in that affirmation. They did not disclose CS leverage loan.
But if you knew that there was an agent for CS, wouldn't that create an issue of fact?
No, Your Honor, because the case law is clear that that's an unidentified principle. Whether it's an undisclosed principle or an unidentified principle, it doesn't matter. It's still both the agent and the principal are part of the contract. And we cite to in our brief the restatement third, and it explains why. Bank of America can't enter into an $18 million trade with an unnamed entity. They don't know the credit risk. They don't know if it's a fraudulent entity. They don't know who it is. How could they possibly enter into that trade?
Okay, thank you, counsel. Thank you. We have your brief as well.
3 points, Your Honor, if I'm able to make them. Paragraph 22 of the standard terms and conditions on page 730 of the record states that the parties agree to be legally bound to agreements by telephone. By telephone. It's in paragraph 22, page 730.
Well, sir, would you run up against a problem under the GOL, the likes of which your friend was discussing with us?
Absolutely not, Your Honor. All the GOL requires is evidence of contract formation. At the bottom of paragraph 3, section 5-701, it precisely states that the writing, which is the confirmations in this case, that's the writing, the writing is not insufficient because it omits or incorrectly states one or more material terms agreed upon. It's as clear as it could be. The material agreement, the agreements in the oral agreements do not have to be reduced to writing in the confirmations or elsewhere to be an enforceable oral contract. And the Fifth Circuit Court of Appeals, the federal court that applied New York law in the Highland Capital case, cited in our briefs, is directly on point on this issue. Second, there is no other trade confirmation in this case other than page 772, which I cited to in my argument. Counsel for the bank referenced the court to page 1033 of the record. This document is not a trade confirmation on page 1033. It does not even identify the loans, nor the amounts, nor the prices. 772 is the trade confirmation. It identifies CS as the principal and the buyer. Third point, if I may. The Bloomberg chat on September 29th is not the trade contract. Van Orden, the trade, if I may, just to finish this point, Your Honor. Van Orden, the Bank of America representative, testified at his deposition, this is page 899 of the record, that at the time of the Bloomberg chat, he didn't have the loans to sell. The sequence went like this. Auerbach for CS said, if you, Van Orden, obtain these loans, my buyer will then enter into a binding contract with you to buy them. Van Orden then goes, obtains the loans from Citizens, and then later, in an oral conversation that's not documented in the record, there's the trade, there's the later trade in which Auerbach agrees for his buyer to buy the loans. That is the trade that is then formed in...
Bank of America remains the lender of record, right?
In a participation, yes, Your Honor.
Okay, and your client is a buyer who participates in the loan.
That is what we saw. That's what Auerbach explained. Yes, as a participant with a participation agreement contract with the lender of record.
Okay. Thank you. Thank you both.
Thank you, Your Honor.
New York City Transit versus Local 100.
Good afternoon, Your Honors. Richard Soder for the Appellant, Local 100. May it please the Court. It has long been the well-settled law, as recognized by the Court of Appeals, by this court, and by its sister courts, that it is not for the courts to interpret the substantive conditions of the contract or to determine the merits of the dispute in an Article 75 review of an arbitration award. And that is precisely what the lower court did when it vacated the arbitration.
Didn't the lower court have to see if the arbitrator exceeded his authority, though? He did have to do that, the lower court.
Yes, there's a threshold question of whether the arbitrator exceeded his authority. We submit that he did not, that he was completely empowered by the contract.
If the arbitrator added the word 30 calendar days, added the word calendar to what otherwise says 30 days, wouldn't that be exceeding his authority?
We submit that he did not add the calendar days to the contract, Your Honor. He was simply making a finding of fact and a finding of law.
It's a hypothetical. How do you answer the hypothetical that Justice Friedman said? What if he had said calendar? That would be clearly exceeding his authority, right?
If he had actually added calendar days to the contract?
That was the hypothetical, counsel. What's the answer?
No, he did not exceed his authority when he made the determination as to what...
That's not the question, counsel. Had he said calendar days, that would have exceeded his authority, correct? If he'd explicitly said calendar days.
Yes, he would have, Your Honor, but he did not. He simply used that as shorthand to determine what the contract provision was. And in 3 pages of argumentation in the underlying arbitration award, that's precisely what he did. It was the job of the court to simply determine whether there was a colorable justification for the determination that the arbitrator came to. And it did not. Instead, it substituted its own judgment as to what the substantive outcome should have been in the arbitration.
Or did Supreme Court just give effect to the plain and unambiguous meaning of 2.1e?
Well, we would submit that 2.1e, that there are 2 competing contract provisions here. And in 2.1e5, there is an important exception there. In computing the time within which any action must be taken under the above procedures, Saturdays, Sundays, and holidays shall be counted, except where otherwise specified. And we would submit that the arbitrator determined that there was enough of an otherwise specification within 2.1c8d for him to determine what the actual meaning of how the day should be counted under that provision of the contract. And once he offered that justification, the court's job was done in terms of reviewing carrying out its Article 75 determination. Court after court, in yourselves, your sister courts have recognized that even if an arbitrator is wrong on the law and wrong on the facts, it is not the job of the lower court or your job to substitute your judgment for the arbitrator, simply to determine whether there was a rational basis identified and followed in coming to the conclusion that the arbitrator did. And that's exactly what happened here and what the lower court ignored when it substituted its own judgment.
Thank you, counsel. Please.
Good afternoon. May it please the court, my name is Lindsay Gosson on behalf of Respondent, New York City Transit. The authority understands that arbitrators are generally given wide latitude when issuing decisions. Although the arbitrators have broad discretion, it's not unlimited, and courts have consistently held that arbitration awards are subject to vacature when the arbitrator exceeds his authority by amending the plain contract language, by adding a term to a contract that does not exist. And that is what occurred here. The arbitrator did not interpret the contract, rather he amended the contract by adding a material term to a clause in the contract that did not exist, and thus he rewrote the contract.
Well, how do you answer your friend's argument that by providing an explanation, a justification for the action that the arbitrator took, that sort of takes it out of the ambit of exceeding his authority?
So here it's our position that the arbitrator ignored section 2.1 E5, which clearly states that when computing time is within which any action must be taken in the above procedures, in that Saturdays, Sundays, and holidays shall not be counted except where specified. The section comes prior, the section in question, I'm sorry, is prior to 2.1 E5. It's 2.1 C8, which comes prior to it. Therefore, the 2.1 E5 clearly indicates that it should apply to the section in question.
Did this provision that's at the center of this appeal, did that otherwise specify, as the arbitrator found?
No, it did not. In fact, because it didn't specify calendar days or specify that Saturdays, Sundays, and holidays shouldn't be excluded, this general provision that I stated before, 1.2 E5, would be the controlling provision. And that's the authority's position here. The language is clear.
And what about counsel's position that it's not absolute?
Well, the language was bargained for, agreed to by the parties. And because it's clear, the interpretation was not required because there's the section at issue, and then right underneath it is the general provision that governs how to calculate the days. And because it wasn't mentioned, right, it wasn't specified that it should have been, then the arbitrator exceeded his authority by adding the word calendar to a section that didn't include it.
There are other provisions in the CBA that specify the use of calendar days, correct?
Correct.
So that if they wanted to use it in this section, it would have been included.
Correct.
Thank you, counsel.
Thank you for your time.
So just one quick point, Your Honors. We go through in our reply brief the various ways that 2.1 C8D could have been drafted to put it completely beyond contestation. And none of those scenarios are at play here. The second that we have a second clause in here saying the 30 days shall be counted, ... We submit that gives the arbitrator clear room to then make a determination on how those 30 days shall be counted. And as long as there has been some justification offered in the opinion that the arbitrator offered, then it's rational, it's within his authority, and it's beyond the ambit of the lower court to overturn and to vacate.
Thank you, counsel. Thank you both. Application for warrant to search premises at Art Institute of Chicago. Please.
May it please the court, my name is Edward Discant. I represent the petitioner and appellant, the Art Institute of Chicago, as I did below. Your Honors, the Art Institute of
Let me ask
Chicago.
you, there's an action pending in the Southern District of New York as to who should get this painting, right?
That's exactly right, Your Honor.
What would your reaction be if we were to say that we're going to hold off deciding this to see what the Southern District of New York decides about this dispute?
So I think there are two components of this. With respect to the merits, frankly, that was our position below, that the court should defer and not do anything at all because the underlying merits were being resolved. But there is a second host of issues which I respectfully submit this court needs to address, which is the authority and the jurisdiction of the court below to conduct the proceedings it conducted at all. And I would submit to you that this court should find that the lower court erred and lacked jurisdiction and authority to do that, irrespective.
But all of this would become moot, would it not, depending on what happened? If you were not to prevail at the Southern District of New York, wouldn't these issues become, I don't know if it's moot, but academic, because then the heirs would get the painting?
So I guess I have a couple of responses to that. The first is I'm not sure it would become moot because, of course, we would then appeal to the Second Circuit, and we would have to see what the Second Circuit did. But assuming you're talking about playing that entire thing out,
Right.
I still think it wouldn't be moot because I still think that the activities of the lower court were in excess of its jurisdiction and authority, and that is a separate and independent harm that, unless corrected by this court, is going to be subject to repetition. The people are actively pursuing similar cases with other out-of-state museums. This is a point the amicus brief notes.
Counsel Amici talked about that there are at least 24 U.S. institutions in states other than New York that have received at least one subpoena from the Manhattan DA's office. You agree with that?
I have no factual basis to dispute it, but it sounds right.
But I take it that your point is that this is going on right now, and that subpoenas are being addressing objects in other states, and therefore, I don't know, capable of repetition or evading review sort of argument. Is that what you're making?
That's exactly right, Your Honor. And that's why I think there's sort of two distinct issues, which are the merits on which, we completely agree that the appropriate thing that the lower court should have done all along was to defer to the pending action in the Southern District of New York. But then there's the separate issue of whether or not the lower court had jurisdiction or authority in a summary proceeding that is not provided for by New York law or statute to try and insert itself into that civil property dispute and then purport to resolve it. It has been New York law for over 100 years that a criminal court does not have authority to do so.
And if we reverse on those grounds that you say, that the Supreme Court didn't have jurisdiction, there are other grounds as well, but it doesn't it wouldn't affect the essentially repugnant action. I don't know if that's the right characterization, but it wouldn't affect the Southern District action.
That's exactly right, Your Honor. And in fact, we respectfully submit that the appropriate response here is to vacate the decision below, quash the warrant so that the Southern District of New York is the court that has authority over the artwork and the property in that dispute.
Can we do that on direct appeal, or do we have to do the writ of prohibition?
So this is an unprecedented proceeding, Your Honor, which is a point that we make, and that's why we brought both different actions. I respectfully submit that the court can do it in either, but certainly the Article 78 proceeding would provide the court with the authority to do that.
Let's focus on the 78, because unfortunately, given the unique posture of this case, if you don't have a direct appeal and your recourse is under 78, then the grounds on which we could afford you relief become far narrower than you would have on a direct appeal. Fair enough?
I don't disagree. I'll simply note that among the problems with this proceeding that the people in the lower court have fabricated, I would submit, is that not only is it not provided by law, but it is the only scenario I can think of in which a court can divest a private party of its property in a way that, as the people would have it, is completely unreviewable on appeal.
So walk me through, I know you have a couple aspects to that Article 78 petition. Walk me through the argument directed specifically at Penal Law 450.10.
Sure.
And how this because you would have to persuade us that the manner in which the people and/or the court employed this was in excess of the court's jurisdiction.
That's exactly right. And that's count 2 of our Article 78 petition. And of course, excess of jurisdiction has been interpreted both to refer literally to jurisdiction, but also authority. And count 2 really focuses on the authority component of that. We believe this court can and should find that the lower court lacked authority to conduct what it called a turnover proceeding and adjudicate the merits of a title dispute between the Art Institute and the claimants. And we believe this court should make that finding because it is a very straightforward application of the Court of Appeals decision in Kempner, which has been New York law for over 100 years. The plain language of Kempner is that a New York court, a criminal court, is not authorized to conduct a trial of Title II or possession of the property taken under the warrant. Very clear-cut holding of the Court
Does
of
it
Appeals.
matter that that decision was rendered in a posture where there were private warrants, and that's not a device that's available now?
Yeah, and Your Honor, it doesn't for 2 reasons. The first is that while it is true that those happen to be the underlying facts of Kempner, the holding of Kempner draws no such distinction. It speaks very broadly about the fact that there is no aspect of the criminal procedure law that authorizes this sort of a trial. I'll note our court did not hold a trial at all. It held a summary proceeding, but there's no component of the criminal procedure law that holds a trial. But the second is that there's no component of 450.10 itself that draws that distinction either. 450.10.5, which is the provision both the court and the people rely upon, simply talks about instances in which property comes into possession of the court. It doesn't say by seizure warrant. It doesn't say, but right. So there's no reason to read Kempner that narrowly based on the language of the statute.
So the painting is constructively in the court's custody at this point.
That's correct, Your Honor.
Constructively. If you were to prevail, what in your view, what should the court do in this circumstance where there is no pending criminal action? There was a grand jury impaneled, subpoena issued in conjunction with that, a seizure in place affected in the course of the grand jury proceedings. Now what should happen to the chattel, the asset?
So we think the most direct thing is for the court to direct the lower court to quash its warrant, to withdraw its warrant, which was never properly issued. That's the geographic jurisdictional. That's count 1 of the Article 78 petition, is that the court never had authority to issue a warrant to seize property in the state of Illinois. That would be one very straightforward mechanism. I think a second related mechanism would be to direct the court to quash the warrant because Kempner makes very clear that warrants should never issue for the purpose of resolving a property dispute. Here, while the people told the lower court in issuing the warrant that they needed the property in furtherance of criminal investigation, that's not actually what they've done with it. What they've done with it is they've used it to immediately commence this turnover proceeding to resolve a property dispute. But third, short of that, even if the court found it couldn't directly or didn't want to directly address the warrant, the remedy would be to direct the lower court to hold the work pending resolution of the litigation in the Southern District of New York, which is where
Or
the
in the
merits...
Southern District, you could apply in the Southern District as well for some kind of attachment?
We could certainly ask Judge Kodal to...
Or the heirs could, excuse me.
Yeah.
Not you, yeah.
Yeah, correct, to do something. But I'll note that is the other problem that these unprecedented proceedings below have created, if I can just finish, which is...
No, I'm sure we have other questions. Keep
Yes, which is that it has set up a conflict between the New York State Court and the federal court when the proceeding in the federal court commenced first. The people acknowledge in their answer to our Article 78 petition that the Art Institute of Chicago remains free to continue to litigate the action in the Southern District of New York. So were this court to affirm, that leaves entirely unclear what would happen if Judge Kodal in the Southern District of New York reaches the contrary conclusion. It's all the more reason it was completely inappropriate for Justice Drysdale in the New York State Court to insert itself into this property dispute, which is already the subject of the pending lawsuit.
Any other questions at this time? I'll ask you a question, counsel. You were essentially the hearing counsel. There wasn't a trial, really.
Correct.
What did you know going into the hearing about what the burden of proof was?
Nothing.
What did you know about, like, who had the burden in the first instance?
Nothing.
And you knew you weren't getting discovery, or you found that out during the course of the hearing, correct?
So the people were ordered at the first proceeding to produce discovery. We got exactly 1 page of discovery from them. We discovered at the end of the proceeding that they had been withholding hundreds of additional pages.
So what, if anything, did you hear about the parameters of this what's the phrase?
Civil-like proceeding? Turnover
Civil-like proceeding. What did you know going into the hearing about the parameters of the civil-like proceeding?
Absolutely nothing, Your Honor, and that is at the core of the due process problems. In every single one of our filings, we asked the court in the first instance to find it lacked jurisdiction or authority to do this, but short of that, to rule in advance, one, we wanted a trial, but two, to tell us in advance what the burden of proof was, what the procedures were going to be. We had absolutely no clarity on any of those things at all. The first and only clarity we got on that, and I would submit there's not much clarity there either, is the decision and orders that were issued in April of 2025.
Can I just ask about in the Article 78, the people answer and say that the Art Institute never said it was improperly seized. This is to Judge Drysdale. Never said that the painting was improperly seized, consented to the seizure, and agreed to litigate and comply with the Supreme Court orders.
Yeah, that's completely false. And with all due respect, Ms. Chang and the appellate counsel who are handling it didn't handle the proceeding below. We never consented to seizure. We made clear from our very first filing that we were challenging seizure, and notably, and we cite this in our reply brief, counsel for the people below conceded that the Art Institute had preserved all of its challenges to jurisdiction and the authority of the court in agreeing to appear in New York to litigate those issues.
Was your first marker on that point the email between you and Mr. Bogdanos?
Yes, Your Honor.
That's at 1623 in the record?
That's exactly right, Your Honor. And that's where the agreement was struck. That was, by the way, not off the record or hidden from Justice Drysdale. The people themselves put it before her. We appeared at the initial proceeding and made clear we intended to challenge everything. And she set, to your point, Your Honor, a motions calendar for us to challenge, among other things, her jurisdiction and her authority. And that's what we thought we were doing. We then asked for oral argument on those motions, which she granted over the people's objection. And we showed up in September of 2024 for that oral argument where we argued about her authority, about her jurisdiction. The one and only decision that we got from her was the April 2025 decision and order.
Justice Higgins, did you have a question? Okay. Thank you, counsel.
Thank you.
Rebuttal.
Good afternoon, may it please the court, Cecilia Chang for the people. I will pick up where we ended on this notion of whether Justice Drysdale, Justice O'Neill-Levy had clear notice of any challenge to jurisdiction or the seizure. We can begin with the series of seizure extension orders that begin on page 17 of the People's Appendix, where Justice Drysdale issued 7 seizure extension orders throughout this proceeding, saying that she was continuing seizure on the joint agreement of the parties and include representations, which she was very careful to document that her seizure was legitimate because the Art Institute promised to keep the painting safe.
What follows from that, counsel?
It follows that there was no notice to Justice Drysdale.
There's no what?
There was no notice to Justice Drysdale of any problem with the initial seizure. Of course, you can consent to seizure. And moreover, I think these representations that where the Art Institute promised it would comply with any turnover decision on the merits and return the painting to the custody of the court within 10 days is a further indication that she had no idea that her seizure or her authority over this painting was in question. Those orders continued even after the hearing itself that counsel just referenced. So they continue from the beginning of the seizure all the way past the hearing to the judge saying, I'm about to issue a decision. I will continue the seizure. There was no contest.
That gave her jurisdiction. Is that your argument? I'm missing something here.
That gave her, there was no notice that the seizure was improper, and the seizure, which puts the property in her custody pursuant to CPL 690-55, is what gives her the authority.
They agreed to the seizure in place, so that happened. And now the question is, how to resolve the ownership of the chattel.
Once they agree to the seizure, then the property is lawfully lodged with the judge and in the judge's custody, and 45010 authorizes the judge to dispose of the property.
So it's your position that they agreed to the seizure?
They agreed to the seizure, or at least did not give notice to the judge that there was any problem with the seizure. Supreme Court is a very busy court, as you know. No one holds proceedings for over a year and writes a 79-page decision when there's a question about their underlying jurisdiction that can be cured, as counsel concedes, through a simple, not controversial procedural step of an Illinois warrant, which the people offered to get. And we did not get simply because the Art Institute said that was unnecessary.
If they had not agreed to the seizure, what would justify you're holding the painting?
If they had not agreed to waive the Illinois warrant, we would have gotten an Illinois warrant. That Illinois warrant would have put the property, if the court agreed, given the property to the New York, transfer to the New York court, and the New York court would have been able to do the same turnover proceeding under 45010.
What cause of action or claim was tried?
The two narrow issues that 45010 says are relevant to turnover are, one, is the property stolen, and two, who has a superior claim of title. Those are the two issues that Justice
And yet
Drysdale
the
decided in
statute doesn't
turnover.
indicate that either of those questions are to be considered. It says if stolen property comes into the custody. It doesn't authorize the court to determine in that instance whether it's stolen. And it doesn't say anything about superior title. It says satisfactory proof of title.
I would refer the court to the Court of Appeals decision in MoMA, where it says that 45010 is the appropriate vehicle to have. In MoMA, which was another Chile painting, by the way, there was obviously a contest over title. That's what spawned the case, because the heirs of Holocaust victims wrote to say that these are our paintings that are on display at the museum. So there's a contest over title, and it was in that context the Court of Appeals said 45010 is the appropriate mechanism.
It seemed to me that that was dictum. That wasn't the actual issue the court was addressing. It was offering thoughts on what may provide a remedy, but that wasn't exactly the issue that was teed up before them.
45010 wasn't a never raised issue. It was actually raised by the trial court in the MoMA case. And the fact that the court found 45010 to be the obvious remedy, I think suggests that it was a non-controversial point of law that the Court of Appeals was mentioning. But an even more important point, Justice.
Well, maybe there's some controversy here, because right down the block from where Judge Drysdale heard this, there's a pending civil action involving the same subject matter. And in that forum, the parties would get pleadings, discovery, accelerated judgment motion practice, a trial if necessary. Maybe someone would be entitled to a jury. And yet, right up the block, all of that was dispensed with.
Judge Kodal in the Southern District action has stayed the federal action pending this court's decision. The judge sua sponte stayed. And I think that's, to return to the questions that began from Justice Friedman and you, Justice Higgett, I think 45010 is designed to solve this impasse. That federal court has now stayed, as you heard counsel said, even if that
take you
federal...
back to what you said before. So it's your position that they consented to the seizure. Had they not consented to the seizure, the basis of jurisdiction or the basis for holding the painting would be that the painting came through New York? Is that what you said?
Well, we alleged, there's a search warrant that was in the record where the people said the grand jury is investigating.
The painting had been in New York at some point.
Yes, the painting had been in New York. In fact, New York was always critical to this painting.
So what's the basis for the seizure if they didn't consent to it?
It was to investigate the crimes of criminal possession of stolen property in the first and second degrees.
And so you need that, do you need that nexus? Do you agree that you need some nexus to New York?
There's, as the Art Institute admits in its reply brief in its very first argument, it never controverted the warrant. It never moved to quash the warrant. And therefore, not only is the warrant presumed to be supported by probable cause.
No, but say, okay, what you say that the nexus to New York was going to the Etienne Studios in 1956, and that's somehow part of a conspiracy involving the Art Institute. Is that correct?
Yes, the importation of this painting was into New York for the first time in the 50s in the Collier Gallery. That is part of
That wasn't on behalf of AIC, was it?
It was not on behalf of AIC, but what we alleged is a series of transactions, which is provenance, by the way. The whole point of provenance in art is to link all the prior acquirers and the transactions to legitimize the chain of title so there isn't collided title. So each of those chains is interrelated. In AIC's provenance search, it lists the New York Gallery.
So the conspirators didn't need any kind of common intent?
They do have common intent to deny that this painting was stolen from the Grunbaum family or Mr. Fritz Grunbaum. And in fact,
so how does the conspiracy engulf AIC?
Because AIC communicated, example of Kornfeld, later on when the heirs made a claim and went to check on provenance. And the theory is that it should have, what Justice Drysdale found, engaged in a reasonable inquiry, which would have required it to do much more inquiry into the provenance of this drawing. But beyond the original sale, we have 2 loans back to New York. And as this court knows, under conspiracy law, communications into New York or transport of property from another jurisdiction into New York, those are all treated as conduct in New York. So when AIC wrote to people in New York or communicated with the heirs in New York, that is conduct that can be viewed as an overt act in furtherance of the conspiracy. But we're only at the investigatory stage. Remember, even
We're
though
only at the investigatory stage, and yet we've determined the proper owner of the work.
this is important, we have not determined final ruling on title that has preclusive effect. The legislature knows how to say final judgment. 45010 solves this problem of proceedings, multiple proceedings going on, and not knowing when or
What's
where.
your position as to this court standing back to await the determination of Southern District Court?
The Southern District has stayed its own action.
We know that,
waiting
counsel.
for
There's
this
sort of like a you first, Alphonse thing going on here. We don't want to do
Okay,
that.
but if we were to say Southern District should decide this first, what's your position as to that?
This is important. The Southern District action is pending, but there's also been a lot of prior litigation on the historical record for the Guanbam-Chiles in Bacalar, in this court's own decision in Neji. So it's not as...
Isn't the Southern District, where there's this clear-cut issue of who owns the painting, isn't that the place where this should be resolved?
It might be resolved if our institute wants to continue to litigate it, but that does not solve the problem of property that is in the search warrant court's jurisdiction and custody right now, and a claim being made that this is stolen property, and the interim disposition of that property is 45010.
But you're saying they consented to the seizure, and then Southern District can just go on and decide who should get this painting.
No, I'm saying that 45010 authorizes the turnover court to make a determination under the 2 statutory
So it's your position, we don't need a decision from the Southern District of New York, but that we should, in this case, decide who gets the painting.
Right, because as in any other case, a determination of possession is not a final judgment on title. So should there be new material circumstances?
So from your perspective, what further fact-finding would be required if we were not to defer to the Southern District?
No further fact-finding, because there was an extensive turnover
There's
record.
enough on the record right now to make a determination.
That's right, and it's the same
Counsel, would that be like some kind of provisional determination? Was I hearing you to say that? Like, in other words, you're saying this is not about determining finally who owns this property? Or maybe I misunderstood you.
I think it's about determining the question of possession right now. Who has superior claim of title right now? And is there a record that allows us to determine the property is stolen and that the heirs have a superior claim
But
of
that
title?
property still could be subject to a replevin order finding the heirs are not the proper owners of the
That's
property.
right, but that would be based on a different...
Is that right? I'm sorry, I misunderstood you.
Well, a turnover order is not... It does not preclude any party from litigating in later civil litigation.
The issue isn't possession. Isn't the issue title?
The issue is title, but what's determined right
So
now...
why do you speak of possession? I mean, right now, if you're correct that they consented to a seizure, so the painting isn't going anyplace, and the Southern District can determine who has title.
I want to back up for a minute. If 45010 did not apply, then this, because the search warrant is uncontroverted and they consented, then under 69055, the property would remain in the custody of the search warrant court, which is Justice Drysdale. So it would never return to AIC. It would just simply remain in the search warrant court's custody. And that is the dilemma that 45010 was provided for the legislature to solve, that might take a very long time. There may or may not be other proceedings. And if there is a claim before me now, and I can determine that that property is stolen, and I have satisfactory proof of superior title, I can order in the interest of justice.
Okay, counsel, where are the procedures that govern that determination? What's the burden of proof? Is there discovery? What is a quasi-civil action? I mean, you say, I'm sorry, I'm getting a little, I don't want to get frustrated here, but you admit that there's an absence of statute of limitations here. You say that they can't even do a direct appeal here. Doesn't that make it look like this is a misfit? That 45010 is not meant to be used for this purpose, where there is a dispute between two parties about the ownership of property.
I would emphasize again that the Court of Appeals referenced 45010 in the context of another Sheely painting from Mr. Grunbaum, where there was
Did it say what the burden of proof was in that?
no, but 45010 always requires an application to the court, and it's the court that orders the turnover. So in a sense, there's no need for the legislature to spell out.
Are there any procedural rules that I don't know about that would govern this particular hearing? Are they specified? They're not, as far as I know. Is that just, I just
Because
confirm that.
there's a wide variety of property subject to 45010, everything from vehicles to perishable property, in this case of stolen art. The court can always set fair procedures, which is what Supreme Court does whenever it hears a motion. And
You can understand our frustration that whatever is done here, now this is not directed at you, the statute is rather sparse in its detail. It doesn't lay out the procedures. And to boot, there's no appeal, right?
that is by legislative choice.
I'm just saying though, so
Uh,
all there is, if we agree with you that there is no, this is not an appealable order, and I think you have, some pretty good authority on your side for that point, that leaves the narrow vehicle of Article 78 and the narrow grounds thereunder. And so it's trying to figure out
There
what
would always
is
be the option, which the Art Institute did not take here, that from the very inception, they could have challenged the warrant and they could have brought an Article 78 prohibition timely within 4 months of the initial warrant or within 4 months of the initial seizure. So there's always that ability for a party to try to challenge it if they really contested jurisdiction, which did not happen here. Second, in Facebook, when the Court of Appeals talked about potential unfairness, the same arguments, the same frustration that this court feels about why search warrants are not appealable, even when a third party like Facebook was raising quite compelling Fourth Amendment claims, which wanted to protect its own customers from Fourth Amendment searches that were overbroad. The court said two things. First, we can entrust these decisions to Supreme Court, to the trial courts in the first decisions, to find a fair solution, which is what Justice Drysdale did in this case. And second, that if there were a violation of due process or some other problem, which is not evident on this record, there could be a civil 1983 action or some other means to address that. But if there were frustration at the absence of procedure in 45010, which I would encourage this court to view as flexibility to turn over court to Supreme Court, a kind of decision that trial courts make all the time when they have to craft reasonable procedures to novel circumstances, that the reason why that is provided is because otherwise there would be a grave injustice and unfairness for claimants who could never claim their property back if it had been seized for a complicated criminal investigation that might take years. It's there to provide a remedy so that people, including art museums, could say, hey, I want my property back. Or, this is stolen property, I need it. That's the solution to the problem. The people brought the application here. 45010 isn't a grant of authority to the people. It's a remedy available to people who have had their property stolen that's in the
Let me just digress, because your time is up, digress back to the Southern District action. What is your view as to the statute of limitations on that action?
The Second Circuit has said that a motion to dismiss for statute of limitations is premature and reversed Judge Kodal, the Southern District judge's ruling on statute of limitations. So right now, there is no ruling on statute of limitations, and there's no binding.
So it's an open issue.
It's an open issue before the Southern District. But again, that court has stayed, which is the normal rule, that civil litigation is stayed pending ongoing criminal investigations and ongoing criminal proceedings, which is why, as this court knows, many people move to stay civil discovery or the progress of civil actions because there's a pending grand jury investigation or a pending district attorney action, which is precisely what we have here. The normal rule is for the criminal investigation and proceeding to proceed first, not the civil action. The fact that there are two parallel paths for return of stolen property, I would encourage the court to view not as a problem, but as a solution because of the strong public policies that favor return of stolen property. The fact that there may be multiple pathways, such as a plebiscite action or a conversion action, doesn't negate 45010. It goes to underscore the policies why the legislature would have wanted to provide a broad remedy for return of stolen property in parallel criminal actions. And also, if this court were to reach the merits, I think Again, this court's decision in Neji outlines powerfully, but also is evident in this record, why the historical record does show that this painting was stolen from the Grunbaum family. The theory that it was not stolen begins and should end with a reported power of attorney that was executed by Mr. Grunbaum, allegedly in the Dachau concentration
See,
camp.
that also, to me, the change in the facts from Baccalaureate to Rife to this case, there have been new facts that have come out. There's a serious question about the efficacy or validity of that power of attorney. That's come out since Baccalaureate. Since Rife, we've also got other new facts that come out. So that, to me, is an argument for a much more thoroughgoing hearing with witnesses and with historians and with everything you need, with a specified burden of proof, with discovery, to nail down the facts, because really it seems like judges by themselves are poor historians.
It might be a different case, Justice Moulton. It might be a different case if an entity like the Art Institute came before the court and said, we're about to go to trial in the Southern District, or we're about to have a deposition of a key witness, and that's why it's too premature to have the 45010 proceeding happen right now. But that isn't what happened, and had that made that claim, there's no evidence that Justice Drysdale would not have listened. It might have been a different case if there had been a specific piece of evidence or a specific procedure that was claimed to make a real difference in this turnover, but there was not. The fact that new evidence might arise would not change the fact that the property would remain seized. The property could remain seized for a very long period of time while we await the historical records development. But again, that is the dilemma the 45010 was enacted to solve, because for the Grunbaum heirs and for people who are the victims of stolen property, they should have an available remedy here to seek that return. That is a principle of long-standing equity in the criminal law, in common law, and equity that says that the court can do equity of property in its legal custody. And
Counsel, I'm going to have to cut you off because unless there are other questions.
thank you for the court's
Thank
attention.
you very much.
So if I can, let's put this issue of consent to bed. This is what Mr. Bogdanos, this is what the people told the court below. He said that AIC had maintained all other rights, including but not limited to challenging jurisdiction. We told the court, that by the way is at Appendix A 1140 and 1141. We challenged the jurisdiction of the court to issue the warrant in our opening filing. That's at A364 and A383, among other places. There is no question that we challenged the jurisdiction of the court and the authority of the court below to issue the warrant. But even assuming there had been consent to the warrant, it wouldn't solve the problem of what happens next, which is whether or not, even assuming a court has issued a valid warrant, which it didn't hear, for property, whether that then authorizes it to conduct an unprovided for proceeding in which there are no rules and there are no procedures. The answer
Well, in fairness to the people, they're taking the statute as they find it, as was the judge below, and they're sort of adopting procedures as the Supreme Court goes along to make the statute work. What comfort, if any, do you get from your friend's point that this turnover order wouldn't be entitled to collateral estoppel?
So none, because it means that they haven't satisfied the element of the statute, which is satisfactory proof of title. My adversary says that they haven't made a final determination. They're still investigating. Well, then they haven't established satisfactory proof of title. But there's a second problem, Your Honor, which is that 45010 does not authorize this proceeding, and the Court of Appeals has said, you can't do this. The people's position is that silence creates flexibility, right? The silence in the statute allows a Supreme Court justice to do whatever it wants. But both the Court of Appeals and the U.S. Supreme Court have said just the opposite. They have said that fundamental constitutional, both state and federal, due process requirements mandate that where the people are going to seek, where a state is going to seek to deprive a party of property The constitutional due process requires trial by jury. There is no flexibility on that point. There is simply no authority provided in the statute or otherwise for the lower court to do what it did, nor is there any jurisdictional hook that would bring this within the ambit of the state of New York, which was Your Honor's question. The only tie that this work has to New York is someone who has been dead for 50 years, named Otto Kalir, held it in New York for approximately a year. There is no connection whatsoever between that event and the Art Institute's acquisition and possession of the work a decade later. My adversary points to
Didn't the work return briefly to his gallery in 1980?
Wasn't his gallery at the time because he was dead. But yes, it did.
He was dead, Mr.
He was dead.
But it was still the Saint Etienne Gallery, whatever gallery it was? Or was it?
The name of the gallery, I believe, maintained his name, but he was dead, which is critical from a conspiracy point of view, because if the theory's people is a conspiracy existed, that conspiracy died when he died. There's no indication of any meeting of the minds, which would be the requirement between the Art Institute of Chicago and him during his lifetime, nor for that matter is there any indication that the Art Institute of Chicago did anything in New York with respect to this asserted conspiracy. A loan of the work for an exhibition, decades later, would certainly not be an act in furtherance.
If the work was stolen at some point, and there's certainly some evidence to suggest that it may have been, you obviously can attempt to controvert that, does that label stolen remain next to the work of art wherever it goes, and from, now till eternity, it remains stolen?
So I think, Your Honor, the core problem is that there has to be an appropriate finding that it was stolen, right? And that's the finding that cannot happen in a summary proceeding. It could happen in a civil claim of replevin, which is what's currently pending in the Southern District of New York. The New York legislature authorized the people to commence a civil forfeiture proceeding. They don't meet the requirements for it here. They're trying to sidestep that. But the legislature has authorized a mechanism for the people to try and establish that the work was stolen. What can't happen, what is not authorized to happen, is for a Supreme Court justice to, in a summary proceeding, adjudicate the fact that it was stolen and then assign it to somebody else. That is a title determination. That is an inherently civil determination. It is one that the Supreme Court and Court of Appeals have made clear must be done through a full civil proceeding, including trial by jury.
Thank you, counsel. Thank you both.
Thank you.
Your briefs were both excellent in this case. A1 Specialized v. James River Insurance. Please.
Good afternoon. May it please the court, my name is Steve Lubell. I represent the appellant, A1. I think the overriding theme here is that both contracting parties, A1 and Arsenal, recognized that they couldn't have it both ways. They recognized that this contract, while there were signature conditions, they both performed under this contract without the signatures. And it is clear that A1 performed, they paid, they agreed to scope of work, they agreed to a schedule, all without a signature. And Arsenal hired a subcontractor, performed the work, and expected to be compensated without a signature. That is an objective manifestation of intent to be bound by a contract without a signature. And therefore, that also means that they waived and did not intend that the signature requirement for the insurance was needed in this circumstance. And therefore, the court below should not have dismissed A1's complaint. In this circumstance, there is case law that indicates that this objective manifestation, based upon the deeds, the acts that were performed by both of the contracting parties, irrespective of the signature requirement, bound both of them to the all of the terms of the contract. They could not cherry pick and pick and choose, and in fact, they did not decide to do that because they both performed under the agreement. One of the arguments that is being raised by my friend is that there was a express condition precedent.
Right, that's
However,
paragraph 14.
yes, Your Honor.
Oh, yeah, you should address that.
Sure. Paragraph 14 of the agreement, the claim is, and that's on page 49 of the record, the claim is that that provision is an express condition precedent. And it says Arsenal agrees to name the contract upon the signing of this document as additionally insured as evidenced by a certificate of insurance that would be provided by Arsenal upon request. That's the key language within that more extensive paragraph. Well, under the case law in this department, very recent cases, Holdco and the other case that we cite from 2024, which is the Parlix case, the court has been very clear and stated that if a provision of a contract is to be considered a condition precedent to performance, there must be an unmistakable intent that that condition precedent must be satisfied. Here, and the courts have actually, in their decisions, have indicated what are the terms that a court will consider as evidence of a express condition precedent and unmistakable intent. Those words, null and void, only if, the other language that's utilized in that provision are not present in that section of Section 14. The court, they don't use the term that, don't buy insurance, this contract is null and void. Don't say unless or until, or if. None of those words are in that provision. So it's the position of A1 that that was no more, and that what Parlix says and Holco says, that it was I know my red light is on. But
Finish the thought.
Sure. What I was going to say is that that is what is considered a contractual promise, and as the case law indicated, by the acts, words, and deeds of the parties, the Parview case that we also, Clover and the other cases, and even Oppenheimer, that the plaintiff cite, that condition was forfeited or waived by the parties in their continued performance under the agreement. I know my red light is on. I'll save for the rest for rebuttal if I have any questions. Thank you.
Good afternoon, Your Honors. May it please the court. Justin Kinney for defendant, respondent, James River Insurance Company. Working backwards from counsel's argument, there is simply no way in my mind you could read paragraph 14 and not conclude it's an express condition precedent. As a legal matter, as an English matter, as a grammatical matter, as a matter of sentence structure. The provision says, Arsenal shall name contractor, comma, upon signing of this document, comma, as additionally insured. What else could upon signing of this document mean if it were not a condition precedent? It is the classic condition precedent, an act or event that has to occur before the contractual obligation is triggered. And I would refer the court to the Second Department's decision in Preferred Mortgage versus Byfield, cited in our opposition brief, where the court concluded that the language directly upon signed acceptance of a commitment was an express condition precedent. Our language here is functionally no different.
So what do you make of your adversary's argument that these parties acted with intent to be bound by this change order? They did the work, they proceeded.
They got the permits.
It's irrelevant to the issue before this court, Your Honor. Your Honors, both of you, for a couple of reasons. Number one, there's actually no evidence of performance pursuant to the change order. The change order is dated December 23rd, 2019. There's been no testimony from Arsenal. There's been no testimony from the plaintiff as to what they did with respect to this particular contract. The building permit is dated over a month before the change order. You can't pull a permit pursuant to a document that doesn't yet exist. The certificate of insurance was obtained 6 months before the change.
The change order concerned the pipe scaffolding work, correct?
That's what it says, yes, sure.
Was Mr. Cuetes and the underlying proceeding injured during the course of that work?
He was injured, as I understand it,
So
Your
that's an
Honor.
inference, isn't it, that the work began, that they started to perform? on-
Certainly, but
right?
I don't think it's a fair inference to say the work began pursuant to the change order. Again,
not?
we don't have any testimony from, in this case, from the underlying plaintiff, from Arsenal, or from the plaintiff in this case as to the sequence of work, what happened, how it came to be that that Cuetes was on the job apparently as of January 2019, almost a year before the change order. But the point is, all the things that plaintiff says evidence some intent to be bound all occurred prior to the change order. And so you can't take action before something exists and say, well, I did it pursuant to that
You
document.
point to the fact that paragraph 14 says upon signing of this document. Is that akin as if it had said, if the document is signed? Would that be different?
Sure, I mean, you could come up with, and I agree, there's
You
case
could come up with better ways of saying that.
Well,
it's a
there is
condition
case law
precedent.
that speaks of classic express condition precedent words like unless and until, if, null and void. But
So is upon
those
the
cases,
signing of this document one of those classic condition precedents?
100%, Your Honor, 100%. And again, I'd refer to the Second Department decision. And those cases that talk about some of the classic words that are used, they don't say those are the only words that create an express condition precedent. They are the classic words. And in this case, upon signing of this document is functionally the same as saying unless and until you sign this document. There's really no different. Thank you, Your Honor.
Just very briefly, in the preferred case, a key issue is that there was never any performance by anyone in that case. Here, there was performance. Not to be flip, but Justice Moulton indicated, asked my friend, can't you draw the inference? If you go to sleep and you wake up in the morning and it's snow on the ground, you can draw the inference. So the only analogy I'm trying to make here, there is a lawsuit by Mr. Cutis, by the underlying plaintiff here, Rosales. He wasn't there gratuitously. He was on that job site performing work. One can infer that Cutis was performing work for a...
Was there any other pipe scaffolding work done prior to the change order?
No, because he was...
We know of.
Cutis came on the site after, as the subcontractor of Arsenal, based upon the agreement. I mean, what other reason would Cutis be at that site? So there is a reasonable inference to make here, highly plausible, that that contract performance was undertaken by both sides, irrespective of any signature by anyone, and they cannot pick and choose which terms to apply and enforce and which terms not to enforce, because they decided to perform under the agreement. And the case law is clear on that issue here. And as Justice Friedman indicated earlier, none of the language that the courts have construed, and this department has construed in recent cases, that would bring this under the ambit of a condition precedent are present in that section 14 of the agreement. If the court has any questions, otherwise we'll stand on the rest of our brief.
Thank you, Counsel.
Thank you.
Thank you both. Brito versus City of New York. Please.
Good afternoon, Your Honors. May it please the court. Julia Audibert with Wilson Elser on behalf of the city defendants appellants. This record contains several material disputes as to how the accident occurred that warrant the reversal and denial of the plaintiff's motion for summary judgment. The plaintiff maintains that as he descended the A-frame metal ladder, which was standing level on a recently finished wooden floor, that he was holding a paintbrush in one hand, descending the ladder, and then he fell as the ladder itself fell to be horizontal on the floor. The record shows, however, several pieces that dispute that account of the event. First, the plaintiff's narrative to the hospital immediately after the accident was that as he descended the ladder, he missed one step on the way down. The second is...
Well, let's stop on the medical record, because
Sure.
is that competent evidence?
Yes, certainly, Your Honor. At the very, very least, the medical record is admissible because it is not the only evidence offered in opposition to summary judgment. We maintain in our briefs that it is also a party admission in that it is the chief complaint and attributed to the plaintiff. But if it is considered admissible as hearsay...
I'm sorry, I may have missed what you just said. Do we know that the statement is attributable to the plaintiff?
In the record itself, it states that it's the plaintiff's chief complaint.
Okay.
And again, at the very least, if it's considered hearsay...
Also, accurate translation's an issue too, counsel, isn't it?
And with that being the case, again, if it's considered hearsay, it is in tandem with several other pieces of evidence.
Not only hearsay, I think it's also, just a problem with, with other issues. It's not only the hearsay issue, it's whether or not it was properly transcribed. But anyway, please continue. What were your other factors that you were going to go to undermine the plaintiff's account of the accident?
Sure, thank you, Your Honor. So in addition to the medical record, the GTL witness, Brian Lindsay, was standing 30 feet away from the accident when at the time it occurred, and his testimony is that he did not hear any accident and that he was there almost immediately afterwards and observed the A-frame ladder that the plaintiff had been working on standing upright and erect immediately after the accident. In addition to that, the plaintiff claims to have been holding a wet paintbrush on the way down, and it was observed that there was no paint or trace of that on the floor, which would be the case if the plaintiff had suddenly fallen and the ladder had gone to the side and he'd gone to the side. There would be traces of paint indicating as such. And in addition to that, the Brian Lindsay, when he testified that he did not hear any accident, there is other testimony by Mr. Arias of conversations with employees who informed him that they also did not hear any type of accident and were under the belief that the accident didn't happen. In this court's decision in Hamill, citation 79 AD 3D 478, the defendants in that case presented evidence very much on point, where the plaintiff's testimony was that the ladder was in good condition, which is exactly the case here. The plaintiff, as well as the foreman who set up the ladder before him, inspected the ladder so that it was stable and level and locked in place. In addition to that, in the Hamill case, the plaintiff testified that the plaintiff stated to a witness that he missed a step while descending the ladder, and there was another witness who saw the ladder standing erect after the plaintiff fell, both of which we have here in this case. And if there are no further questions, I will remain my time for the rebuttal.
Thank you, counsel.
Thank you.
May it please the court, Stephen Gustafson of McCormick and Priori on behalf of third-party defendant, appellant JLM. I do not want to repeat what Ms. Audibert said. I think that is the real crux, as the trial court judge put it. The fact that the plaintiff was the only witness to his accident does not preclude summary judgment in his favor when nothing in the record controverts his account of the accident or calls his credibility into question. And by credibility into question is, whether he can be trusted to have observed things correctly and recount them correctly. It's not saying that somebody is some sort of archfiend. And the briefing is replete with problems such as counsel just discussed, and whether or not plaintiff repositioned the ladder, whether he was told to use it, whether he had the brush in the hand or whether he had both hands on the ladder. These are all contradictions in his own testimony as well as in other people's testimony of what happened with him.
As far as having two hands on the ladder, How is that relevant?
Because he also said in another place in the 50H of the deposition referred to, that he was taking the brush down in one hand. So he contradicted himself, and hey, it's a long workday. If you've ever worked in a factory or someplace like that in physical labor all day, you do get tired. So you could misremember for a number of reasons. But the court's summation citing the Roku versus
I take it that his cause of action is based on the sudden unexpected movement of the ladder. And so whether he had two hands on the ladder or not, I don't see how that really...
Well, the ladder, when you look at it, when you look at the, as they put it in, as plaintiff put it in the brief at page 9 of the brief, cited the plaintiff, so after 5 minutes I came down so I could dip the brush again. And as I was going down the ladder, moved to the right, but then I went to the left, and that's where I fell. And when I fell on the left side. Immediately beneath that, counsel for the plaintiff writes, as the ladder suddenly moved to the right, and in the full range of this briefing, the things the plaintiff wrote, you know, you don't want to have to take a shot every time they use the word sudden or suddenly, but it was not, at least in this citation, that they gave us.
Was there an alternative, like scaffolding or something that would have been a little safer if this ladder was wobbly, something else the plaintiff could have used?
Well, there was testimony about Baker's scaffolding, but, you know, the stories of the use of the ladder, there's no, just to use the incantation that the ladder moved, and then, you know, have that remove all issues of credibility, all issues of, you know, say that it moved without talking about the magnitude in the movement. Was it a 1/4 inch? Was it a 1/5 of an inch? Was it 5 inches? Was it 5 feet that it moved? Did it skid on the floor? Or did it just rock back and forth instead of skid? No, we have the incantation of the magic word moved, and that everything is supposed to be down the road to Tipperary from there. And, you know, we would submit that that's unwise and that this case is illustrative of that. And, you know, it's very important, as the judge said, the fact that plaintiff was only witness does not preclude when nothing in the record controverts. We'd humbly assert that there are things in the record which controvert the account or call the credibility into question without saying that he's Lex Luthor. It just, it doesn't parse out.
Thank you, counsel. You have time.
Thank you, Your Honor.
May it please the court, Efrem Mortenthal for the plaintiff respondent Brito. There's not a shred of evidence, of admissible evidence in this record that the accident happened in any other way than the plaintiff stated it happened. He's working on the ladder. He has to re-dip his brush into the paint because it's out of paint. That's why he's going down the ladder. And he's about 4 or 5 steps, about 5 feet up. The ladder shifts to the right, he falls to the left, and he's injured. He loses consciousness. Israel Martinez, his foreman, comes in. At some point later, he sees him on the floor.
He sees the ladder lying on the floor.
And he sees the ladder horizontally lying down on the floor. All this time, Mr. Lindsay is nowhere near there. So he doesn't know what's going on inside,
And
obviously.
neither is Josaphat Arias there either.
He's not at the place. He's not even at the premises. But
Can the court consider the Bellevue record where he stated that he missed a step?
no, there are 4 problems with the Bellevue record. Number 1, it's not germane. Number 2, it's not attributed to the plaintiff. Doesn't say Mr. Brito states. Number 3, it's not certified. Number 4,
Do we know if he got an
speaks only
interpreter?
Spanish, and he doesn't speak English. These are 4 problems. I mean, if this is the medical record that has everything going against it. So there's no question of issue that this is not admissible. They have nothing else to rely on. They said, well, Mr. Lindsay comes in and he sees the ladder upright. Mr. Lindsay repeatedly testified in the records at page 803 and 819. They asked him, do you have any knowledge if somebody moved the ladder or lifted it up, put it in the upright position between the time of the accident and the time you went in there? He said no. He has no idea. Israel
He also
Martinez,
said he did not know whether the ladder was the one the plaintiff was using when he fell.
that's also correct, because he wasn't there. We have no idea how long after the accident he went in there. In fact, Israel Martinez, the person who set up the ladder for the plaintiff in the first place with the drop cloths, and he set up nicely underneath the fixture, he was there. He's the one who came to the plaintiff. He saw he was semi-conscious. He's helping him out. He helps him out into the hallway. Very well, it could be that Israel Martinez could have put the ladder upright. I mean, he put it there in the first place. So Mr. Lindsay has absolutely no knowledge as to whether or not the ladder was ever moved. And he says he has no idea if anybody else was in the room, when in fact Israel Martinez was in the room. We have no knowledge as to how much time elapsed from the accident until Mr. Lindsay finally went into the room. So the mere fact that he allegedly saw that the ladder was upright is not inconsistent with plaintiff's testimony and the testimony of his foreman, Israel Martinez, that the ladder was lying horizontally on the floor. With respect to any other available safety devices such as scaffolding, under Gallagher versus New York Post and this court's decision in Maltese versus the Port Authority, you have to make a showing. There's a three-part showing. Number one, you have to show that the plaintiff was aware of the scaffold, that he was expected to use it, and for no good reason, he failed to use it. They haven't shown that the plaintiff is aware of it. In fact, the only evidence in this record is the plaintiff said in the 3 to 5 days that he had been working there, prior to the accident, he did not see any scaffolding on the 3rd floor, which is exclusively where he was working. So he didn't know of any scaffolding. The testimony of this record is by all the defense witnesses is that they have no knowledge of anybody ever telling the plaintiff to use a scaffold. Each witness of the defendant said that they have no knowledge of that. And also, furthermore, his own foreman and supervisor, Alex Lopez, instructed him to use a ladder. It's late at night, he says, we've got to finish up this job by midnight. Use whatever ladder you can find. Israel Martinez, his other foreman, sets up the ladder for him. So he's doing exactly what his employer told him, what his supervisor, what his foreman tells him to do. The cases are numerous that say that if you're following the instruction of your supervisor or your foreman, you cannot be the sole proximate cause of the accident. With respect to not identifying any specific defect with the ladder, there are dozens and dozens of cases from this court which state that the plaintiff does not have to identify any specific defect with the ladder. If the ladder shifts or moves and causes him to fall, which is the only evidence in this case, it's a Labor Law 240 case. Unless there are any questions, I'll rest on my brief.
Thank you, counsel.
I'll begin with the point on the testimony of Martinez. The testimony of Martinez versus the testimony of Mr. Lindsay is entirely a credibility dispute, not ripe for summary judgment. Mr. Martinez on page 856 of the record says that he does not know how long after the accident he was there, or how much time passed between the accident occurred and when he arrived at the scene. Also, the idea that he could have put the ladder right back up, it could have been him that made it erect, is completely speculation. There's nothing to that point. And Mr. Lindsay, on the other hand, was the consistent testimony is that he was 30 feet away from the accident. And so even if Mr. Lindsay was 30 feet away, Mr. Martinez testified that he was outside on the 1st floor putting the trash out, and then does not know how long from that point of taking the trash outside to when the accident occurred, how much time had passed. Those two different versions of the accident is just an issue of fact that must be decided at trial. And it is Mr. Lindsay's testimony, the fact that he saw the ladder erect, that's consistent with the medical record of he missed a step on the way down, and that is what caused the accident. And to the point of the medical record, any issues with the medical record are curable for a jury trial. And again, it would be consistent with one of the several accounts of the accident that can be inferred from the record. And then as to the shift of the ladder that the plaintiff claims is what caused the accident, this is not a case of an uncontroverted shift. This is a case where there are multiple inferences as to how the accident occurred, how the plaintiff fell off, what happened and what caused it. And just as a side note, on page 571 of the record, there is testimony that even after painting, and with supposedly you need more paint for the ceiling that he was using it for, there would still be paint on the brush that would cause traces of it on the floor that would then show after an accident as the plaintiff describes. Thank you.
Thank you, Counsel.
Council's covered virtually all of the points I wanted to mention. I do want to add just a minor statement of the many things discussed was whether or not a plaintiff slipping on a step of the ladder was germane to his treatment. And common sense would tell one, I'm trying to resist citing my own history. Common sense would tell one that just simply falling over onto the ground on the one hand and reaching for something with your feet and then having it go out from under you, which it puts a strain on the whole lower stomach area. Those are very different things. So I read a number of people say in this case it's not germane. I don't know how that can be reasoned. Thank you.
Thank you, Counsel. Thank you all. Rigard v. 509 West 34th. Please.
Good afternoon. May it please the court. Patrick Lawless for Wilson Elzer for the defendant's appellants. I'll try and be brief. The Supreme Court erred in granting plaintiff summary judgment because there's issues of fact as to how this accident happened. There's a sworn statement from the plaintiff's coworker, Mr. Sanchez, and Mr. Sanchez's account of the accident is incompatible with the plaintiff's version of the accident that he fell through the hole.
He said, Mr. Sanchez said he ended up falling forward and to his side and landed on the third floor deck.
Yes, so if you look at the photograph and the description, there's the third floor deck, then there's a depression. It looks about 6 inches, and then within that depression is the hole. So if he's falling forward and landing on the deck, he's not falling into the hole because the hole is within the depression, not on the deck.
It's quite a hole.
I'm sorry?
It's quite a hole.
It's a big hole, is what my colleague
Yeah.
But Mr. Sanchez doesn't say, oh, Enrico's leg didn't go through the hole or anything like that, does he?
He doesn't say that, but that version of the accident is not compatible with him falling
How
in
much
the
of
hole.
defendant's leg ended up in the hole? What's
sorry?
what's the evidence of the extent of defendant's leg that ended up in the hole?
The only evidence of the plaintiff's right leg going in the hole is the plaintiff's statement. Nobody else saw the leg go into the hole.
But didn't Sanchez state he stepped onto some plywood that gave way and fell?
Yeah, he said he stepped onto the plywood, which gave way and fell into the hole, but he doesn't say that the plaintiff fell into the hole. He said that the plaintiff fell forward and landed on the deck. So if he's landing on the deck, he's not falling through the hole. And then he said the plaintiff was able to sit up by himself. He doesn't say, I had to pull him up out of the hole. That's what the plaintiff said. Plaintiff said Sanchez had to come over and pull him up out of the hole, where Sanchez says that the plaintiff was already sitting on the deck when he went over to him. So based upon that, there's enough of an issue of fact as to warrant the denial of summary judgment.
Thank you, Counsel.
Thank you, Your Honors. I think you have picked up the major points I was going to emphasize. That according to Mr. Sanchez's statement, he said when he stepped aside, he stepped onto some plywood that gave way and fell. It's totally compatible with plaintiff's account. And in fact, Mr. Sanchez went and told at least 2 other people who quoted that his leg did go into the plaintiff's leg did go into the hole. So
Doesn't Rowan Titley say one leg went into the hole?
Excuse me?
Doesn't Rowan Titley say that?
He says that because based on what Sanchez told him, and also the Ross Vananden, the foreman, he was also told everybody knows that his leg fell into the hole. So there's no dispute as to that, and I don't see any other dispute as to any facts. There are controlling case law, the Carpio decision of this court, let me just make sure I have the subsequent decision in Favaloro. By the way, they allude to the Favaloro decision without mentioning that in Favaloro, the plaintiff was granted summary judgment on facts that are essentially the same as the facts here. As to the 241-6, in Favaloro, the court denied, I think dismissed his 241-6 case because there was no evidence of the dimensions of the hole. But as Justice Friedman has pointed out, this was a very big hole. It was at least 3 by 5. Mr. Titley said that he saw 2 people inside the hole. It was 18 to 20 feet long, deep rather.
So in other words, if you'd fallen from the hole, you would have fallen 18 to 20 feet.
If he had gone through the hole, and there was plenty of room for him to fall into the hole. So under all those criteria, there was a violation of Section 240 and also Section 241-6 based on the Industrial Code Regulation 23.1.7b. So if there's no other questions, I know it's been a long day for all of you, and I won't prolong my argument any further.
Thank you.
Thank you very much, Your Honor.
Just very briefly, I'd like to point out that Mr. Titley did not witness the accident himself. He said it's a hearsay statement, which what Mr. Sanchez purportedly told him, but that doesn't match what Mr. Sanchez's own sworn statement actually says. And again, if you're saying it's a big hole, the plaintiff was saying that Mr. Sanchez would have had to help him out, where Mr. Sanchez is not saying I helped him out of the hole. He said he fell on the deck and he was already sitting up on the deck when I went over to him. So based upon that, there's enough of an issue of fact to deny summary judgment.
What about this is a hazardous opening? What about the fact this is a hazardous opening and needed to be better protected?
It did not cause the plaintiff, it wasn't the cause of the plaintiff's injury. The plaintiff fell forward, not into the hole. The plaintiff fell forward and to the right. So it would be a hazardous opening case if he fell through the hole, but the issue is he didn't fall through the hole, he fell forward, and that's this court's decision in Polonium. When you're falling forward or tripping, that's not a hazardous opening case. Thank you.
Thank you, counsel. Thank you both. Last but not least, Fisher v. Hudson Hall. Please.
May it please the court. My name is Glenn Grinlinger, and I represent Hudson Hall and Think Food Group, which are affiliated with the humanitarian Jose Andreas. This court has held for over 50 years when a plaintiff asserts a claim based on a violation of a statute, the plaintiff must specify the statute allegedly violated. This is not a difficult lift for a plaintiff to make. Yet here, plaintiff did not allege a substantive violation of a provision of the New York labor law. That omission is fatal to his
Your position in counsel, of course, is that it's not sufficient for him just to describe the alleged wage theft, but he must cite chapter and verse the statute.
He must allege the statute that is violated. That's
198 sub 3 would be the one that would cover these alleged actions, correct?
I'm sorry.
Labor law 198 sub 3 is not cited.
198.3 is a remedies provision. It is not a.
Oh, I'm mixing it up. Sorry, right.
It is not a substantive provision. He has to allege a substantive provision of the New York labor law.
Right.
And that's set forth.
That's
in
a
our
separate
papers.
issue. I'm sorry. I was missing the correct section.
Not an issue, Your Honor. Now, this court, as I said, has long held that you need to, that alleging the facts is not enough. You need to actually allege a statute. And there are very good reasons for that. Liability is premised on the violation of a statute. Without knowing the statute, defendant could waive affirmative defenses that it did not know it necessarily had, because some of these affirmative defenses are set forth in the statute itself. Secondly, there is the uncertainty of potential damages and remedies that may be at issue. For example, in opposition here, plaintiff raises the 191 claim, which was never raised before, but those are different remedies than are available under 198.3. And thirdly, it helps the parties understand what scope of discovery is going to be necessary. For example, If we had known that plaintiff was going to raise a 191 claim, and we did not know that, and still don't know that because it was only raised in opposition to our appellate brief, we would certainly be asking questions in discovery about how often was he paid. The record will show that he was paid weekly, and those records are set.
Sir, if you were on
Yes.
notice of the substance of the claims in the complaint, couldn't you have requested a bill of particulars in which the plaintiff would have to specify or particularize the statutes or regulations on which the plaintiff was relying?
We could do a bill of particulars, but that would occur after issue is joined, and we shouldn't have to. We should know what we're fighting before issue is joined, so that we can properly prepare our defenses and determine whether we want to do a bill of particulars or interrogatories, because we can't do both. And so for that reason, we would argue that the trial court was incorrect in denying our motion to dismiss, and that this court should overturn that order and dismiss the complaint in its entirety. If there are no more questions, I will reserve my remaining time for rebuttal. Thank you.
Good evening, Your Honors. Ronnie Gouldman for the plaintiff respondent. Now, there are really two sets of disagreements on the instant appeal. One is about what kind of violations New York labor law covers. And essentially, appellant's position is that if, say, you worked 42 hours, but you are only paid for 40 hours, that you have a cause of action because those 2 hours were overtime. But if you worked 40 hours, but were only paid 38 hours, you don't have a cause of action under New York labor law. So that's one set of questions. And the other one—
Also, just stopping you there, is that the no wage theft loophole act that you're trying to argue right now?
that is one of our arguments.
Haven't we already held it that doesn't apply retroactively? That statute does not apply retroactively?
Well, I guess that is true. That isn't the case. But we would urge the court to reconsider that, which is within its power.
Do you want to respond to his pleading question that the particularity of the statement in the pleading was not sufficient because you didn't specify? I think it's now 195 sub 3. I mean, you should have done that.
I would say it's CPLR 3013 that specifies the pleading requirements. And I won't read it now, but it does not include a reference to statutory requirements. You have a lot of federal case law, which we cited, which of course is not binding, but nevertheless instructive, I think, because they say what matters is not whether you specify the exact cause of action, but whether you specify the facts, the predicate facts for the cause of action, and whether there is a cause of action. Now, one can say, well, that's fine, that's the federal courts, but I don't think that the pleading requirements in New York are higher than those in federal court, particularly after Twombly, Iqbal and Twombly in federal court. And beyond, as to the retroactivity, the plaintiff is asking the court to reconsider. I know that it has said in cases that there's we have found no indication of why it should be retroactive, because yes, it's a remedial statute, but that in and of itself is not grounds for retroactivity, which is the case. But it's not just that. There are, as we quoted, clear statements of legislative purpose and understanding that that many courts have erred in how they have interpreted deductions in 193. And if you think that they've always been doing it wrong all along, that is certainly a reason to impute an intent for retroactivity. And another point you made is that one common reason why courts may be reluctant to impute retroactivity is the possibility of unfairness. But again, not paying somebody what you've agreed to owe them has always been unlawful under breach of contract in any case. So making it retroactive I don't think would be egregiously unfair to the defendants. And beyond the retroactivity issue, the court may disagree, but it seems to us that the Court of Appeals clearly spoke in Ryan versus Kellogg Partners, which is cited by the New York legislature in passing the No Wage Theft Loophole Act. Can I, please? And they're basically saying, yeah, we're passing this. We shouldn't have passed it. We shouldn't have had to pass it in the first place because you have a Court of Appeals decision in 2000. Well, first of all, for many decades, no one raised the idea that deduction has this narrow meaning. And secondly, if you look at Ryan versus Kellogg Partners, if I can just a quote, just 2 lines here. Since Ryan's bonus therefore constituted wages within the meaning of Labor Law 191, Kellogg's neglect to pay him the bonus violated Labor Law 193. Now in Perella, this court said, well, okay.
Thank you, counsel.
Okay, thank you.
You got the point.
Thank you, Your Honors.
2 quick points, Your Honor. Your Honors, excuse me. First of all, with respect to retroactivity, the Wage Theft or the No Wage Theft Loophole Act of 2020 was passed in 2021. Since that time, on 4 separate occasions, this court has held that statute does not apply retroactively. In Perella in 2024, Francis, Canthan, and Raparthy, I may have been mispronouncing that, which were all set forth in our papers. Secondly, with respect to the notice pleading issue, this court held in Alvarado versus New York City Housing Authority, it states, where the complaint alleges a statutory violation, the pleader is required to specify each statute claimed to be violated. That's all we've been asking, and we still have not gotten that. And that's based on that alone, the complaint should have been dismissed. And if there are no more questions, I thank Your Honors.
Thank you very much,
Your Honors.
counsel.
I know
Thank
it's
you
been a
both.
long day.